All right, good afternoon. I'm Delegate Wells. You're joining us today with the Government, Labor, and Elections Subcommittee, joined by my Vice Chair, Ken Kerr. So for each bill, we will hear from the sponsor and their panel, followed by an all in-person witnesses, then virtual witnesses. Testimony is limited to 2 minutes. Sponsor testimony will not be timed, but please be courteous with how you use that time. And with that, we will be starting off with HB 263, the State Board of Elections. Is it just going to be you, Mr. Demaris? Okay, all right.
Sorry. I was busy from the other
all
stuff.
That time to get
exactly,
ready, man.
Right? I didn't even get a snack or anything. Yeah, so sorry. Here, hold on. So just give me 2 seconds to pull up 263. Oh, the bus stops.
All right, let us know when you're ready.
All right, perfect. Sorry, thank you.
You ready?
Yes.
All right, all yours.
Thank you. So Jared Demaris, State Administrator of Elections. This is a great bill that for enfranchising voters here is about early voting and bus stops here. So when we select early voting sites, we make sure that the early voting sites are along transportation routes. However, you can't guarantee that the transportation route and the early voting site are exactly at the bus stop along the line there. So this bill basically says that if a fixed county bus line is within a half a mile of an early voting center, that during early voting, that the bus will stop right in front and make that a bus stop during those 8 days of early voting. This will help a lot of people that use mass transit, so to vote without any need to walk or have battle any sort of elements along the way there. So this is a great bill, and I firmly support it and helps enfranchise more Marylanders. So thank you.
Thank you. We have Ms. Morgan Drayton next. Is that correct? Good afternoon, Ms. Drayton.
Good afternoon, Chair Wells, Vice Chair Kerr, and members of the committee.
Sorry, just so folks know, and I apologize to interrupt you, we'll start your time over. You literally have to speak all the way into the mic for some reason, so I just want folks to know to bring it as close to you as possible. Thank you.
Good afternoon, Chair Wells, Vice Chair Kerr, and members of the committee. My name is Morgan Drayton, Policy Manager with Common Cause Maryland, and I'm very excited to be testifying in this new committee for the first time in support of HB 263. We appreciate this step that the State Board is taking towards making early voting as accessible as possible to all voters. We know that a lack of access to reliable transportation remains a strong barrier to voting for many residents of the state, and we think that this is a good first step towards making early voting as accessible as possible. We would urge SBE to advertise the program as widely as possible in all places that promotional materials are shared, including inside the actual buses themselves, just to make sure that the public is aware that this program is being offered. And we would hope that in the future, SBE and the legislature would consider making bus trips to the polls free of cost to the voter. And for those reasons, we would just request a favorable report. Thank you.
Thank you. Oh, I see we have a question from Delegate Ruth.
Thank you, Madam Chair. My question is for Mr. Demaris. I'm just wondering why this is only for county and municipal bus routes and not MTA bus routes. Is it just that would have been too costly?
Yes, MTA, yeah, they had a lot of technical issues, and so yes.
Thank you.
Thank you, Delegate Ruth. Seeing no other questions, I believe that ends the hearing on HB 263. Yep, so thank you so much. So we move on now to HB 267.
Sure. Thank you. Jared Demaris, Maryland State Board of Elections, State Administrator of Elections here. This is our other departmental bill here. Basically, this is a good governance bill here about campaign finance reporting and just really defining the role of the treasurer. And it really, a treasurer can't be a person in name only. So this basically says that they're the financial steward of the campaign finance entity, but allows flexibility of a modern campaign to say that they can have agents to work upon and work for the campaign to make expenditures, as long as the treasurer is aware of the activities that those agents have. And everything is in writing, so it's auditable, and that we can then make sure that for enforcement actions, there is no unauthorized purchases or expenditures that go on. So this is, making the treasurer aware of all the responsibilities and duties that they have for the overall arching committee. It's making them more of like the CFO, and then making that then anybody who acts underneath that CFO has to be aware of their responsibilities and have a fiduciary duty to the campaign in a written trail, so that we know that no one is doing something unauthorized here. Additionally, it just basically clarifies too who can make expenditures for a political action committee between the role of the chair and the treasurer. It just gives the chair the similar powers that they have for central committees, which is the chair is the one that kind of operates the political action committees there. So that's kind of it in a nutshell. And then the other portions of it is just changing terminology from chairman to chair to a more universal policy there. And then some other little cleanups as well. But that's kind of the big ticket on there, and I welcome any questions.
Thank you. Okay, seeing no questions from the committee, that ends the bill hearing for HB 267. Thank you very
Thank you.
much. Next, if we could have Delegate Polakovich-Carr presenting HB 157. Do you have a sponsor, a panel? Okay. Yes.
If they could come up too.
I think I have listed here Morgan Drayton and Nikki Tyree. Is that correct?
Yes, Common
Perfect.
Cause and League of Women Voters.
Okay.
Madam Chair, thank you. Well, good afternoon, committee. It is great to be before you for the first time. For the record, I'm Delegate Julie Polakovich-Carr, here to present House Bill 157. This bill is about ensuring public transparency for a particular type of campaign committee, exploratory committees. For my few colleagues who were on the Ways and Means Committee previously, you might recall this bill from last session, and I'll note that the Senate cross-file of that 2025 bill did pass the Senate unanimously last year. So as we all know, every candidate who runs for a state office, whether it's governor, attorney general, delegate, senator, et cetera, has to comply with the state's campaign finance laws. And that includes periodically reporting to the State Board of Elections about the money the candidate has raised and how that money is spent. And we all just filed those reports a few weeks ago. And these reports ensure that there is public transparency and accountability for money in politics. But there's a loophole in our state's current campaign finance laws and system. And that loophole is one specific type of political committee, exploratory committees, which are not required to disclose their donors or expenditures. So an exploratory committee is a way for someone to test the waters of a potential run for office. For example, you might want to see if you could be a viable candidate for, say, governor or attorney general without officially declaring as a candidate. An exploratory committee is a temporary and legal way to raise money and to spend money to determine if the person should proceed as a candidate or not. Exploratory committees are allowed in Maryland under regulations that were issued by the State Board of Elections, and these rules allow a potential candidate to raise money to pay for polling, communications with voters, and other activities to help determine whether or not they could be a viable candidate. Unfortunately, the current state regulations for exploratory committees do not require any reporting about the committee's finances, including who they receive money from or how that money is spent. This bill would require exploratory committees to be transparent about contribution and expenditures, just like any candidate or political action committee in Maryland is required to do. Notably, exploratory committees for federal offices are required to disclose this information already. So we're just bringing the state into line with what federal exploratory committees do. In addition, the bill makes some other tweaks to the state regulations. For instance, it slightly expands the list of allowable expenses for exploratory committees, requires an exploratory committee to wind down after a window of potential candidacy has closed, and it allows more options for how remaining funds can be disposed of at the end of an exploratory committee. So collectively, these policies will ensure that prospective candidates can test their viability before pursuing a formal campaign, while also ensuring full campaign finance transparency. Thank you for your consideration.
Good afternoon, Chair Wells, Vice Chair Kerr, and members of the GLE Committee. I'm Nikki Tyree, Executive Director for the League of Women Voters of Maryland. We want to thank Delegate Plovakovich-Carr for bringing this bill again. Generally speaking, exploratory committees go unchecked with very little recognition around them and regulations around them. It basically allows these committees to put untold amount of dollars into campaigns, sending out mailers, putting out name recognition, digital communications. In a democracy, you want to have candidates that have to run robust, fair campaigns, and the exploratory committees do have a way of snuffing out competition before campaigns really take hold of the public. This bill would establish parameters around disclosures that more align with current campaign finance laws, as well as closing out and giving that window of off-ramping money as we certify those candidates who are violated. So for that, the League of Women Voters is asking for a favorable report.
Hello again. My name is Morgan Drayton, Policy Manager with Common Cause Maryland, here in support of HB 157, which, as we heard, would apply existing campaign finance laws and requirements to exploratory committees. And I also want to thank Delegate Plovakovich-Carr for bringing this legislation. As you've heard, Maryland has a very well-developed system of campaign finance law, and that system ensures that the average citizen can trace who's making these donations and what special interest voices are heard within our electoral processes. Given the amount of money that is spent, kind of testing the feasibility of an individual's campaign, we strongly believe that exploratory committees should also be required to adhere to that same level of scrutiny. It's very critical that citizens should be able to see who's funding these efforts. This legislation ultimately will allow for greater disclosure and transparency around committees, and so for those reasons, we request a favorable report. Thank you.
Thank you. I think that was an accidental, but you were wrapping up.
I got
so
it all out.
I apologize. I want to apologize for that. You are always very efficient.
Thank you.
Are there any questions from the, okay, I see no questions from the committee. That ends the bill hearing for HB 157. Thank you very much.
Thank you.
Next, I see we're joined by Delegate Stein. We will hear Delegate Stein's bill, HB 182. And do you have a sponsor panel, Mr. Weinberg? Is that correct? Okay, so you can bring him up with you. Good to see you.
Thank you. Well, good afternoon, Madam Chair, Mr. Vice Chair, and committee members. Nice to be before you. And so House Bill 182 deals with the issue of faithless electors, that is presidential electors who cast ballots for candidates who did not win the popular vote in their state. And this was something when I put in this bill once before a couple of years ago, didn't pass, but up until then, I really wasn't aware that this was potentially a significant issue. But in the 2016 presidential election saw the largest number of faithless elector ballots being cast in modern history. And, given the fact that, sometimes the electoral vote can be very close, a matter of a few votes, this issue is something that potentially could be impactful. Now, last year, in 2024's election, there were no faithless electors who cast ballots, but faithless electors have appeared in multiple prior elections. So 24 states have strong enforceable laws that would prevent a situation like this happening, but Maryland does not. In Maryland, the law is that electors are directed to vote for the candidates for president and vice president who receive a plurality of the votes cast in the state of Maryland. But state law has no mechanism to prevent or remedy any elector who wants to go rogue and cast a ballot for the person who did not win the plurality of votes in the state. That vote would be counted and the elector faces no consequences. So this bill is intended to address that gap. It's modeled on the Uniform Faithful Presidential Electors Act recommended by the National Conference of Commissioners on Uniform State Laws. I know that is a mouthful, but what the bill does is that it establishes alternate electors who are pre-designed in case a ready substitute is needed, and I'll get to a situation where that substitute might be needed. It requires electors and alternates to sign pledges of faithfulness that they will vote for the nominee for president and vice president of the party that appointed them. And this is really the key part. It provides that an elector who fails to vote for the presidential or vice presidential candidate of the party that nominated them is deemed to have vacated the office. So if in Maryland under this bill, if an elector decides to go rogue, then that faithless vote is not counted. And under the bill, the alternate elector is appointed to vote in that elector's place. And so the bill would ensure that Maryland will not have faithless electors in future presidential elections. It's supported by a broad coalition of groups, including the ACLU, Black Girls Vote, Common Cause, the League of Women Voters, and Protect Democracy. And attached to the testimony of Mr. David Weinberg, who'll be testifying next, is a support letter signed by 12 groups. And I've also submitted several sponsor and amendments that are mostly technical. So with that, I urge a favorable report. Thank you, Madam Chair.
Mr. Weinberg?
I think we've got a witness beaming in who would be well positioned to go next, actually, if that's all right.
We typically do the in-person and then we do virtual.
Okay.
Yep.
Got it.
I
Thank you.
appreciate your generosity.
Sure. Chair Wells, Vice Chair Kerr, and distinguished committee members, thank you for the opportunity to testify today. My name is David Weinberg, and I'm here as a policy strategist for Protect Democracy United, a cross-partisan 501c4 that seeks to strengthen the representative institutions of our system of government. I'm also a proud Maryland resident. We commend Delegate Stein for championing House Bill 182, and we encourage you all to approve it with the sponsor's amendment. Our country's founders originally meant for presidential electors to be autonomous decision makers, but quickly realized that this approach was untenable, so they revised it with the 12th Amendment. That step acknowledged and facilitated the Electoral College's emergence as a mechanism not for deliberation, but for party line voting by the electors, as the US Supreme Court put it in unanimous rulings 6 years ago. Those rulings upheld the right of states to bind and replace their presidential electors, so none of their electoral votes would get wasted due to faithlessness. That decision was encouraged by 47 states, including Maryland. The recent spike of faithless electoral votes in 2016 that Delegate Stein noted hints at a problem that could become calamitous. Contemporary presidential electors receive incessant letters, phone calls, emails, lawsuits, and even death threats. Now, threats and acts of political violence have dramatically increased in recent years. Consider how much worse such pressures might be against someone who, for 6 weeks, has the power to overturn a presidential election. Lately, we've also seen federal powers systematically abused to coerce law-abiding people across the country. It would be reckless to presume such coercion won't also be directed at our presidential electors the next time a sore loser will not admit defeat. Thankfully, states can pass laws to automatically replace any faithless electors. Roughly half of all states already have laws of this sort. This bill is like an insurance policy. We make drivers buy insurance before they get behind the wheel. Shouldn't we apply the same level of caution to our electoral votes? Thank you for considering this bill with the sponsor's amendment.
Thank you very much. And we'll now hear from a virtual witness, Ms. Carrie Bierman. One moment. Hi, Ms. Bierman. Can you hear us? Okay. Good afternoon. You're here to testify on HB 182. You have 2 minutes. Ms. Bierman, can you hear us?
Oh, yes. Thank you
Yes,
so
you can
much,
begin.
Chair Wells, and members of
Absolutely.
the committee, for this opportunity to speak in support of House Bill 182, which would enact the Uniform Faithful Presidential Electors Act in Maryland. I'm Carrie Bierman, Legislative Counsel at the Uniform Law Commission. Just a little bit about the Uniform Law Commission. We are a 134-year-old state-supported organization. We're a group of volunteer attorneys that provide states with nonpartisan, well-conceived, and well-drafted legislation that aims to bring clarity and stability to critical areas of state law. Our study and drafting process is open and inclusive, and it encourages participation by persons with a wide variety of perspectives and subject matter expertise. You will see commissioners are practicing lawyers, judges, and legislators who are appointed by all 50 states, as well as the District of Columbia, Puerto Rico, and the U.S. Virgin Islands. So Mr. Weinberg and Delegate Stein did a wonderful job of summarizing the contents of this bill. And just one thing to note, that the Uniform Faithful Presidential Electors Act has been enacted by 13 different jurisdictions since it was finalized in 2010, and 5 states are considering the act in addition to Maryland this session. I would be happy to answer any questions that the committee might have. Thank you.
Thank you, Ms. Bierman. Are there any questions from the committee? Okay. Seeing none, that concludes. Thank you, Delegate Stein and Mr. Weinberg and Ms. Bierman. That concludes the bill hearing for HB 182. We will now move on to HB 221. Delegate Boucher. And Delegate Boucher, who will be joining you on your sponsor panel?
Ms. Steinbecker.
Dr. Kashima Cross, is that correct? Or Bradshaw?
Bring the mic up.
I'm so sorry.
Introduce yourself.
All right, Ms. Steinbacher and and Bradshaw. Correct, okay, thank you.
Thank you.
And one virtual witness.
Thank you very much.
Okay, thank you.
Good afternoon, Chair Wells, Vice Chair Kerr, and honorable committee members. This does not look like the Republican caucus room right now.
Because it's not the Republican caucus room right now.
For the record, I'm Delegate Christopher Eric Boucher, representing District 5, representing Carroll and Frederick counties, but don't hold that against me. It is with humility and honor I present House Bill 221, Primary Elections Change of Party Affiliation Bill. The purpose of this bill is to reform a constitutional flaw I perceive in the existing language of the law regarding voters' rights in a primary election cycle, of which I believe, based upon my experience before the Maryland State Supreme Court, could be challenged for case law. The existing process allows an unregistered voter to appear at a polling place during the primary election, register to vote in a party affiliation of their choosing, and then proceed to cast a ballot in the party of affiliation they had just registered. However, an existing registered voter, be they Democrat, Republican, or unaffiliated, shows up at a polling place during a primary and wishes to change their party affiliation and vote in a new affiliation cannot. They can change their party affiliation, but they cannot vote in that primary with the new affiliation change. This discriminatory treatment of existing voters from having the same voting rights as an unregistered voter runs afoul with the United States Constitution, Amendments 14 and 15, equal rights and voting rights. Additionally, the Voting Rights Act of 1965 can be used in a legal argument as well. To have 2 separate sets of rules for primary registered voters and unregistered voters, that's unintentional or maybe intentional, depending on your perspective, cause voter turnout in primaries to decrease, further exacerbating the polarization of the political climate in civil discourse. By allowing those individuals who are already registered to vote to change their party affiliation at the polls, voter turnout will increase. This move will cause the representatives elected to find more common, amicable ground in the center of the political spectrum to legislate for the good of all, not just the special interest groups that dominate the election process for outside interests outside the average constituency. This is not an open primary bill where you do not need to be a party member to vote in a political primary. Such a policy runs afoul with a basic premise that no one has a right to vote in an organization they are not a member of. Upon further review and reflection of this reform measure, I feel confident that a majority of this honorable and intelligent body will agree that this is a very good, sound, worthy bill to pass. It in no way satisfies all sides and must therefore be a good bill. Therefore, I humbly request this honorable body consider and pass this bill. Thank you very much, Chairwoman.
Thank you, Delegate. And just for your witnesses, a reminder that you each have 2 minutes to speak.
Thank you. Thank you, Chair Wells, Vice Chair Kerr, and committee members, as well as Delegates Bouchat and Hornberger for bringing forward this bill. The League of Women, and I'm Cheryl Steinbacher with the League of Women Voters, Maryland. The League wished to address the benefits of HB 221 that would provide the opportunity for over 1 million Maryland voters to cast their ballots in a primary election. Last year in October, the Bipartisan Policy Center issued a report addressing the effect of more open primaries on voter turnout and representation. They found that primaries that are open to all voters have become more widespread over the past 2 decades, rising from 17% to 25% of all elections. Fully open primaries tend to result in primary electorates that better represent all voters. And finally, when states allowed all voters to participate in primaries for the first time, voter turnout increased and the electorate grew more demographically and politically representative. Maryland currently has over 1 million registered voters, approximately 25% of its electorate, who are unable to cast a ballot for primary partisan offices, thus leaving only nonpartisan school board positions on their ballot. Many voters feel they have no say in who will represent them, and in Maryland, 25% of them are absolutely correct. Excluding 1/4 of registered voters from meaningful participation in primary elections undermines the principles of fair and free elections and does a disservice not only to Maryland voters, but to the candidates as well, who are denied the opportunity to earn their support. Every election, we keep tabs on and then bemoan the low turnout numbers during primary elections, when in actuality, the design of the process ensures that will always happen. This is definitely a bold bill that will provide the broadest voter representation possible and expresses voter choice.
You can just begin to wrap up.
We encourage you to commit to a bold decision and vote in favor of this bill. Thank you.
Thank you. Mr. Bradshaw, excuse me. 2 minutes.
Chair Wells, Vice Chair Kerr, Chair Wells, Vice Chair Kerr, and members of the committee. I'm Lee Bradshaw. I'm with the Maryland Forward Party, and I can keep it well under 2 minutes. We agree with the previous 2 speakers. However, we take a point of view more from the unaffiliated voter side, and we support this bill. It's favorable with amendments. We'd like to see it align more with 496, and we're going to hear more about that next week. We think that 970,000 or so unaffiliated voters who are unaffiliated for a reason, and they want to be able to participate in the primary process without having to register with a party. So thank you, sir. We appreciate your effort and Delegate Hornberger's effort to open up the primary system, and we support this with amendments. Thank you.
Thank you. Are there any questions for this panel? Delegate Tomlinson.
Oh, no.
Delegate Boucher.
Good afternoon, sir.
Just wanted to clarify. So this, when if somebody somebody who's unaffiliated goes in the day of the election, they're not just voting in that primary. They are a member of that party until they go back and change it. Correct?
Right. The premise of this is, if you're an unaffiliated voter or even a registered voter of another party, you can go into the primary election and change your party affiliation that day and vote on that ballot of the party you have just joined, but you'd have to vote on a provisional ballot. And then from that day forward, you are a member of that party unless you want to switch to another party. It gives more fluidity to the system, which I think is what unaffiliated voters are really trying to find, a chance to be able to vote in a primary, but that runs afoul of the entire premise that you should be a member of an organization to vote in it. So this would overcome that hurdle, and I think it'd be a really good compromise. And if you're an unaffiliated voter and you really don't like that party anymore, then the next election cycle, you can go back to unaffiliated or join another party.
All right, thank you very much. All right. Seeing
That was
no-
easy.
It's what happens after the bill. That's the hardest part. That ends the bill hearing for HB 221.
I must say, this was actually better than Republican caucus. Y'all have a good day.
I don't have a dog in that fight. All right, with that, we're living up to the glee of this committee. With that, we will move on to Delegate Fair, HB 156.
Thank you, Madam Chair. And if I'm not mistaken, am I the first person to present on our committee, to our committee? Which
You are the first person on the committee to present to the committee.
Which I heard the rule was we immediately must move that bill favorable.
Yes.
That's the
All right, Delegate Fair.
Chair Wells, Vice Chair Kerr, and esteemed members of the newest and greatest committee, the Government, Labor, and Elections Committee. For the record, I am Delegate Chris Fair presenting House Bill 156. The bill simply allows unaffiliated voters to participate in any party's primary election by giving those voters the option to register with a political party and cast an appropriate ballot during early voting. Now, you might be saying, I just heard this bill. You did. This is slightly more tailored, so this only applies to unaffiliated voters, allowing them to register with any party when they go to their primary early voting center. This is a reintroduction of legislation championed by Delegate G in 2024, who graciously allowed me to carry it forward here in 2026 with her as our primary co-sponsor. This bill would add Maryland to the list of 16 states that take a similar approach. Those states include Arizona, Colorado, Illinois, Indiana, Iowa, Kansas, Massachusetts, Maine, North Carolina, New Hampshire, New Mexico, Ohio, Rhode Island, Tennessee, West Virginia, and Wyoming. All Maryland elections, including primaries, are fully funded by taxpayers. Therefore, all elections should be inclusive rather than disenfranchise almost a quarter of voters in key elections. House Bill 156 creates this exact opportunity. This bill is not a mandate on political parties. It is an opportunity for unaffiliated voters to take the time to choose which party's candidates they would prefer to cast their primary vote for. This bill is especially important as many voters who are unaffiliated are first-time voters, young voters, new citizens, or citizens who have moved from a state with open primaries. Many unaffiliated voters in Maryland are not fully aware that they are only eligible to vote in nonpartisan primaries while they remain unaffiliated. And this legislation gives them every opportunity to affiliate and then participate in a partisan primary election. By not allowing unaffiliated voters every opportunity to participate in critical primary elections, the current state of the law disenfranchises them. Finally, I uploaded an opinion from the Attorney General to the bill file, certifying there are no constitutional problems with this legislation. In conclusion, primary elections are crucial decision points with significant ramifications for the general election, paid for by every Marylander, regardless of party affiliation, and every Marylander should have the opportunity to participate in them fully. For these reasons, I urge the committee to return a favorable report on House Bill 156. Thank you, Madam Chair.
Thank you, Delegate Fair. We have a question from Delegate Ruth.
Thank you, Madam Chair. Thank you, Delegate, for bringing this bill, a really important bill. Unaffiliated voters are, I think, the fastest growing pool of voters. Do you have data of like what types of voters are registering unaffiliated or why they might be growing so quickly?
Yeah, so the leading charge on unaffiliated voters, from the data that I've seen at least, and I would certainly defer to the state board administrator on getting the more specific, getting into the weeds, but are younger voters, as they are initially registering to vote, they are registering as unaffiliated and feeling, for whatever reason, not connected or just not, there's been no outreach or not understanding like the power of being able to affiliate with a party. And so this gives them a little bit of time to learn, oh, if I'm not affiliated with a political party, then I can't actually go to the polling place and select that party's candidate for the general election.
Thank you. And I follow up, Madam. Thank you. And I understand anecdotally that immigrants are also tend to register unaffiliated. Is that something that you have data on as well?
Yes, absolutely. And so, yeah, I think
I
I
mean,
mentioned.
naturalized citizens, I mean, of course.
Of course, yes, and that is built into my my testimony as well. That
Thank you.
naturalized citizens.
Thank you, Delegate Ruth. Delegate Kerr.
Thank you, Madam Chair. Something just occurred to me, Delegate Fair, that the ballots for the primary are pre-printed by party with I guess, an estimation of voter turnout. So could there be a situation where you run out of ballots if an unprecedented number of unaffiliated people show up? And maybe it's a better question for the administrator, but just occurred to me. I don't know if you've thought that through.
Yeah, what an amazing problem to have if we could do that, right? And so the state board has weighed in, certainly offline on this issue, on this question of how many resources they would need to make sure that we have the appropriate number of ballots at the polling places in order for them to be able to handle the potential influx of provisional ballots that they'll need to file that day. And so that's certainly a consideration that the committee will want to take under advisement.
All right, thank you.
Thank you.
You're welcome. Delegate Wu.
Thank you, Madam Chair. For the delegate sitting there, who are the co-sponsors?
Yeah, that's a great question. I absolutely knew that right off the top of my head.
I have an answer. I think I just comment on the question earlier.
Yeah.
For a lot of new immigrants or new citizens, when they try to register vote, they don't understand the complication. You have to register a party to vote for a lot of elections. So that's the reason a lot of new voters, they're non-partisan, right? They choose unaffiliated or independent.
Yeah.
Then once the habit happened because they got disenfranchised because they couldn't vote, right? That actually further defranchise their voting in the future. So I really love the idea of this bill. Thank you very much for sponsoring.
Well, thank you very much. Thank you. I appreciate that, Delegate Wu.
All right, thank you. Seeing no more questions for the bill sponsor, we are joined by, if they can come up to the table, Morgan Drayton, Nikki Tyree, Leland Bradshaw. And I do have, oh wait, there's not enough, but I do have for information, David Naiman. I don't know if you're in the audience or not. Okay, all right, I see you. All right. Well, I'll have you come up once a seat opens up. And a reminder to folks, you guys are all very seasoned, but 2 minutes. We'll begin with Ms. Drayton.
Okay. For the record, my name is Morgan Drayton, Policy Manager with Common Cause Maryland, here in support of HB 156. As you've heard, currently registered but unaffiliated voters who would like to register under a recognized political party to participate in Maryland's closed primary process must do so 21 days before the election. We know that this is a big problem in our state, where the number of unaffiliated voters has grown rapidly over the past decade. Voter registration data from SBE from January 2026 shows that nearly 1 million voters in Maryland are currently registered as unaffiliated. And as we've heard, few are aware that such registration will affect their ability to fully participate in our state's primaries. While those hundreds of thousands of Marylanders can freely participate in the general election, they are unable to meaningfully participate in our closed primary system. And in a state where demographic realities and partisan gerrymandering basically guarantee many races to certain political parties, our current way of doing things leaves unaffiliated voters shut out of of the most important election in the process. HB 156 would allow more voters to have a more meaningful impact on the democratic process in a way that wouldn't materially affect the state's current preference for closed primaries. So for those reasons, we support HB 156, and we would urge a favorable report. Thank you.
Thank you. Ms. Tyree.
Thank you. Again, Nikki Tyree, Executive Director for the League of Women Voters of Maryland. As you've heard, the unaffiliated voter group is growing. It makes up about 25% of our total voter population here in Maryland. A lot of this is young people who feel not represented by either party, or worse, a growing belief that parties are the same, and they're not. And we have our immigrant community who have been naturalized, who don't understand the party system, don't feel feel comfortable registering with a party system, or again, don't identify with either party. And what we have also started encountering is this general group of people who are becoming apathetic of the parties, again, with this growing notion that the parties are the same, or they just are disgusted and want out of that system. However, the league believes that they should still have an open doorway to being able to participate in our most important election. Here in Maryland, most of our elections are decided in the primary, and by locking out these voters and not giving them any avenue to participate, we are essentially telling 25% of our voters that their opinion and thoughts actually don't matter. So this bill would open up a pathway for those people to be able to register, cast a provisional ballot, go through the standardized checking period to make sure that they are eligible, and to have that vote get counted. And we believe that all voters should have access, and Delegate Fair has brought a great first step to that ability. So we urge a favorable report. Thank you.
Thank you, Mr. Bradshaw.
Yes, hello again, Lee Bradshaw with the Maryland Forward Party. Again, we think that the 970,000 or so unaffiliated voters who would like to participate in the primary system in a state-funded election should be able to do so without having to register for a party. And so we support this bill with amendments, and the amendments would be to make it line up more with 496. Thank you.
Thank you. Mr. Naaman, did you want to speak, or were you hearing? Okay, all right. I will give you a chance to speak, and then we can open up for questions.
Chair Wells, Vice Chair Kerr, Subcommittee Chair Fair, and members of the Government Labor and Elections Committee. My name is David Naaman. I'm the president of the Montgomery County Board of Elections. It's an honor to be here testifying for the first time at your committee with elections in the name. Thank you. And it was an honor to meet in Frederick with Chair Fair before the session. Our board voted on Monday to take no position for or against House Bill 156, but to provide informational testimony about its effect as currently written if it were to apply to early voting for the June 2026 primary election. The bill would require a challenging public education effort in a limited time frame to let people know that any registered voter can change their party affiliation until June 2nd. No one can do so from June 3rd through June 10th. Only unaffiliated voters could vote a valid provisional party ballot at early voting on June 11th through 18th, and no one can change their party affiliation from June 19th until July 6th. We can only guess how many of our county's 188,000 unaffiliated voters might choose to vote in party primaries and where, since they've never had the chance to do so before for partisan elections. Since any unaffiliated voter making that selection would vote a provisional ballot, we would need more provisional ballot election judges to address that increase. Being a provisional ballot election judge is one of the more difficult and stressful election worker positions, since even minor errors or omissions can result in the boards being required to invalidate otherwise valid ballots. Recruiting, retaining, and training provisional ballot election judges is among our most difficult tasks. More provisional ballots usually means longer wait times for voters and may require more time for us to count them and to get final election results. Finally, candidates may have planned their strategy and their budget around a certain primary election electorate and then would discover late in their campaign that a large but undetermined number of additional unaffiliated voters may have been added. Thank you for the opportunity to present this information, and I'm happy to answer any questions.
Thank you. We have a question from the Vice Chair.
Thank you, Madam Chair. Delegate Boucher's bill required a constitutional amendment. This bill does not. Can you tell me the difference?
I think that's a question for the sponsor.
No.
No further questions.
My understanding is the flipping of the the party, allowing a party to reaffiliate with a different party would actually change our elections process, or that they just put it in just because. I would defer to committee counsel on that one.
Sorry. Yeah, you actually don't need a constitutional amendment for either bill.
Yeah.
Yeah, it's just statutory.
Yeah.
Delegate Tomlinson.
I basically have the same question that I asked Delegate Boucher, and I think with your bill, they're not actually, am I correct? They're not actually changing their affiliation. They're just kind of a one time only. They're participating in a party's primary. Is that right?
No, in both cases, in both bills, in order to vote in the primary, in order to make sure that we protect the party's rights for affiliation, right, you have to actually affiliate with that party. So if I go in as an unaffiliated voter and I want to vote the Democratic ballot, I actually have to change my party registration to Democratic.
Okay.
Now I can walk out after the election, and on the appropriate date thereafter, after the election's over, I can then change my party affiliation right back to unaffiliated.
So they both are the same in that context. Okay, thanks.
Yep, they are.
Okay, seeing no more questions, that ends the bill hearing for HB 156. Next, we will call up Delegate Feldmark, who's presenting HB 44. And I know that you have a second one, HB 145. Do you have a sponsor? Yes, please. I just want to acknowledge that we have a little bit of a committee showdown at this moment with the chair of Ways and Means, the vice chair of Ways and Means in here. So I just want to acknowledge that for the public. Yes. No. Delegate Feldmark, you may begin.
Thank you, Madam Chair. Wonderful to see you, Chair Wells, Vice Chair Kerr, and to the members of the Government, Labor, and Elections Committee. It's great to be with you. For the record, I'm Delegate Jessica Feldmark, here to present House Bill 44, Election Law, Petitions and Ballot Questions, Contents, Plain Language Requirement, and Procedures. So ballot questions, everyone's favorite topic, can be some of the most important issues we vote on. They can be some of the most controversial issues we vote on. And they are often the most confusing items on the ballot. Ballot questions are notoriously cumbersome in their language and can be unclear or even counterintuitive in what it actually means to vote yes or no. This bill aims to correct that by simplifying ballot questions. Each question would have to have a brief title in bold that describes the topic, goal, or outcome of the ballot question. A short statement describing the change in policy to be adopted in plain and clear language that will be easily understandable to voters, that does not get into the legal mechanisms providing for the policy change, and that does not contain legal jargon or use double negatives or passive voice. The choices the voter has, and a brief statement explaining what the practical outcome of each voting choice would be. A vote yes means, a vote no means, right? And in addition to simplifying the ballot questions themselves, this bill would also require easy access to additional information for those seeking more detail. Now, as you know, ballot questions describe something else, some other measure, either a bill that was enacted and referred to the ballot, a constitutional amendment. And so those other items that are being described, this would require the Board of Elections to post the full text of that item on their website. So it would be easily accessible. And you could link directly to the MGA website or the county website that has the full detail for the legislation that started that ballot question. So this bill will help simplify ballot questions, empower voters with clear information, and encourage stronger civic engagement across Maryland. Thank you for your time and consideration. I'm happy to answer any questions, and I respectfully request a favorable report. Thank you.
Thank you. We have one question for the sponsor from Delegate Lehman.
Yes, thank you.
Thank you so much for this bill, Delegate Feldmark. So quick question about the link to the websites. Is the purpose of that to provide additional context for the question so that it's not, a standalone without any additional sort of background information or context or history?
So there are two components. So the Board of Elections would have to post the full text of the bill or constitutional amendment that the ballot question describes. And then the link to the MGA website, as you know, our webpage for each bill has a whole host of information, who testified for it, who testified against it, what the testimony was. So if people want to do a deep dive, they can do the deep dive. We're just making it easy for them to find that information.
Okay, and this quick follow-up, is this the first time you've brought this bill, did you say?
It is not.
It's not, okay.
This bill in this form was introduced last year. It did pass the Senate. It did not pass the House.
Thank you. Thank you, Madam Chair.
We're trying again.
We will now hear from your sponsor panel. Ms. Tyree, I'll begin with you.
Thank you, Chair Wells. Again, Nikki Tyree, Executive Director for the League of Women Voters of Maryland. We want to thank Delegate Feldmark for being such a champion for this bill. The League believes that this is a very easy step to take. If you look at the fiscal note, there is no fiscal note on this bill because it is just using the existing resources. So far too often, what we hear back from voters is that they participate in what we call undervoting, which means they vote for the offices and then they get down to ballot questions and they just stop voting, partly because they can't understand what the ballot question is saying, or if they do understand it, they don't want to vote wrong. The best example of that is my mom in the last election quizzed me up and down about how to vote for the reproductive choice ballot question, and we went over it, and I told her this is what you do. She left her paper in the car, and then she voted wrong, which is horrendous, and I hope she's not watching, but that is what happened. And she came home and she was very, very upset about this choice. And I explained to her that unfortunately, without Delegate Feldmark's bill, she would not be the only person to vote in a way that they did not want to vote because of the way that the questions are worded. So again, I hope this is one of the easiest bills you can pass this session. It really is for the voters. So just think about that when you think of this bill. So we urge a favorable report. Thank you.
Thank you. Ms. Drayton.
Thank you, Chair Wells. For the record, my name is Morgan Drayton, Policy Manager with Common Cause Maryland, here in support of HB 44, which simply ensures that all ballot questions and petitions are written in a way that can be reasonably understood by a voter regardless of their level of education. As Nikki said, too often we're seeing voters leave the polling booth unsure of how they voted on a question or having skipped over certain questions altogether just because they weren't sure what they were being asked. I think we can all agree it's very important that voters are conscious and informed about the decisions that they're making at the ballot box. It's also important that voters don't feel left out of the policymaking process by unclear or intimidating ballot language. I want to make it clear that this bill is not meant to question the intelligence of Marylanders, but acknowledges the realities of the educational makeup of our state and country and makes necessary accommodations. We believe that these measures should be taken to make voting on petitions and ballot measures more equitable for everyone. HB 44 would do that, and for that reason, we urge a favorable report. Thank you.
Thank you, Ms. Drayton. And we have one virtual individual testifying, Mr. Matt Rice. Wait, Matt Rice. Mr. Rice, I think we can see you. Can you hear us, Mr. Rice? Oh, hold on one second. We can't hear you, Mr. Rice. One moment. Are you by any chance, is your microphone on, Mr. Rice? Okay, we can hear you now. We can hear you. If you could please begin again, because we could not hear you the first time.
Certainly, I
Thank you.
apologize for that.
It's okay.
For the record, my name is Matt Rice. I am the executive director of People on the Go Maryland, which is Maryland's statewide self-advocacy and systems advocacy organization ran for and by those with intellectual and/or developmental disabilities. Distinguished committee members, honorable chairperson, I thank you for the opportunity to testify in support of HB 44, which would allow for election ballots and petitions to be in plain language. This is very important for people with intellectual and/or developmental disabilities so that we can understand what it is we're voting for and have a clear understanding of the issues. Voting is our most fundamental right that affects all of us, and it also affects not only people with intellectual and/or developmental disabilities, but the elderly, non-native English speakers, and so many others. This is a common sense piece of legislation that will make it easier for people to vote. Therefore, I respectfully ask for a favorable report. Thank you.
Thank you, Mr. Rice, for your testimony. Okay, seeing no more questions from the committee, that ends the bill hearing for HB 44. We will now move along to HB 145, Delegate Feldmark. Do you have a sponsor, do you have a panel for this?
Yes.
Okay, if they could please come up and join you and state their names.
Hi, committee.
Yeah, it's off. Hold on one second. Did you push the button? Okay. You're good. You're good.
There we go. Sorry about that. I'm Charlotte Fleckenstein. I'm with the Maryland Association of Counties.
Hi, I'm Sarah David. I'm with the Office of the State Prosecutor.
Jared Demarinis, State Administrator of Elections.
Go ahead.
Okay. Thank you, Madam Chair. And good afternoon once again, Chair Wells, Vice Chair Kerr, and members of the committee. For the record, I'm Delegate Jessica Feldmark, here to present House Bill 145, Election Law, Election Misinformation, Election Disinformation, and Deep Fakes. Election misinformation and disinformation are among the most serious threats to our democracy. They suppress voter participation, create confusion, and undermine trust and confidence in our elections. And with the use of generative artificial intelligence, the potential threat posed by election misinformation and disinformation deepfakes is growing exponentially. Imagine a few hypothetical examples. A deepfake video of our governor holding a press conference, declaring a state of emergency and rescheduling Election Day. Or maybe the deepfake video depicts our very own state administrator of elections, advising that voters that due to a technical error, mail-in ballots won't be accepted for that election. There are endless possibilities of different types of mis or disinformation, ranging from dramatic to mundane. And with the use of AI, deepfakes can be frighteningly convincing. This bill would prohibit a person from knowingly or with reckless disregard to use or disseminate deepfakes to produce materially false information if they have the intent to use the deepfake to impede, influence, prevent, or attempt to impede, influence, or prevent a voter's decision to cast a ballot, misrepresent facts relating to voter registration, voting methods, election results, electoral processes, or official duties of an election official, or induce or attempt to induce another individual to sign or not sign a petition for a question to appear on a ballot. If a deepfake containing election misinformation or disinformation is circulating, then first and foremost, we need to stop it and correct the information. This bill would authorize our state administrator to do so. It also authorizes the State Board of Elections to file civil action to seek damages if it incurs costs in the process of having to correct the misinformation and disinformation. And in addition to the board's civil action, the state prosecutor can also pursue criminal prosecution. And you'll hear shortly from Sarah David, who can speak to that in more detail. And before we turn to my panel, I do want to mention I have already submitted to the committee an amendment. That amendment would conform this bill to its cross-file in the Senate as it came out of committee. I do also want to highlight we will be asking for an additional amendment. There was some components of that were discussed that did not make it into the final amendment to ensure that those entities that are protected from criminal prosecution would also be protected from the civil action that the state board might take. And if you have detailed questions on that, that's why Mr. DeMarinis is here. So certainly that's in the committee's hands now, but I just wanted to highlight that for you. So with that, I thank you for your time and your consideration. I'm happy to answer any questions and respectfully request a favorable report.
All right. Delegate Terraza. Delegate Terraza?
My apologies. I'm trying to figure out how to get these hearing aid things working, and because I'm having a lot of trouble hearing in here. But thank you, Madam Chair. Can you just say a little bit more about the conforming amendment? And just, I understood that it conformed, but I don't understand what it actually changes, and then what the other change is.
Sure.
And you may have said that while I was adjusting my hearing aids.
No, I did not walk you through it. We did provide a reprint, and I'm happy to speak to that. So there is a requirement in the bill for broadcasters in terms of their exemption, requiring them to make a good faith effort to establish that the deep fake is not deceptive or fraudulent deep fake. The challenge that came up, and I think you have some testimony to this effect from the favorable with amendment, right, is that broadcasters really don't have that level of direct interaction with paid advertising that they broadcast. So that good faith effort was not realistic for the relationship between the broadcaster and a paid advertiser. So that was one component. And also clarifying in, I believe, a couple locations where the bill referred to using or disseminating a deep fake. We're adding create, use, or disseminate. And I believe, and we'll ask Ms. David to speak to it, that is an important piece in the prosecution as well.
Great, thank you.
Delegate Ruth.
Thank you, Madam Chair. And I'm not sure if this is something that you can answer or if it should wait for your expert witnesses. But as these things get better and better, how are we going to be able to detect that they're deep fakes at all?
I'm going to leave that to my expert
Okay,
witnesses.
thank you.
Actually, to the body, if you don't mind, can we just get through the favorables, and then Delegate Wu, if you're okay, I'll have you ask your question. Thank you, I appreciate that. So we'll move on to the next person, Miss David, is that correct?
Yes, thank you. Good afternoon, Madam Chair and members of the Government, Labor, and Elections Committee. My name is Sarah David, and I am the Deputy State Prosecutor at the Maryland Office of the State Prosecutor. For those of you who don't know, our office handles political corruption, police misconduct, and election law violations throughout the state. In recent years, artificial intelligence tools have become more available and more capable. As elections experience new challenges related to the use of artificial intelligence in our elections, our laws have to also adapt. That's why we encourage a favorable report on House Bill 145 and thank Delegate Feldmark for her leadership on this issue. I'm going to focus on discussing the provisions that start with subsection C, as those are the criminal provisions of the statute. This criminalizes the intent to create the deepfake and disseminate the deepfake, not just the creation. And that's really important for First Amendment protections. When the intent is satirical or when the intent is to do something funny, that's not what's being punished by this statute. This is when the intent is fraudulent. Also importantly, this legislation is about fraud used to impact a voter's decision to vote. It criminalizes the use of artificial intelligence to show, say, an image of a polling place on fire, or advising someone that the election is over and not to vote, or to purport to be an election official saying that it's over or they found false ballots. This addresses issues related to voter suppression. Maryland actually has a history of this. In 2011, our office prosecuted a campaign operative who orchestrated a robocall into African-American communities, advising them that the election was over and the Democratic candidate had already won. Think about how much more persuasive that would be if it was an AI image of someone like Mr. Demarinis conveying that message. Thank you so much. I'm happy to answer questions, and we encourage a favorable report.
Thank you. Ms. Charlotte, how do you pronounce your last name?
It's Fleckenstein.
Thank you.
Yes, ma'am.
Ms. Fleckenstein.
Yep, so for the record, my name is Charlotte Fleckenstein. I'm the Legislative Services Assistant with the Maryland Association of Counties, testifying today in support of House Bill 145. I'll try to keep it brief. I know we've heard a lot of election law this afternoon, and Delegate Feldmark and Ms. David have done a really great job explaining the contents of the bill and some of its specific provisions. So I just want to add that as a result of AI-generated and manipulated content, local election officials have been facing heightened pressure, a lot of misinformation-driven confusion, and increasingly, unfortunately, threats and harassment that are tied to false election narratives. Counties are important players in local election administration efforts, often on the front lines, and local boards of elections do face the direct security and operational costs that arise when misinformation runs rampantly unchecked. This bill helps protect voters from misinformation that is designed to manipulate electoral outcomes, and ultimately it is a highly relevant and timely piece of legislation that responds to the realities of our digital age by providing a balanced statewide framework to support free, transparent, open, and fair elections. And as such, MACO is respectfully urging a favorable report on House Bill 145. Thank you.
Thank you. Mr. Demarinis?
Sure. Jared Demarinis, State Administrator of Elections. I'm here for information purposes only here, but I think that this is a good bill because it helps bifurcate the two immediate needs, which is one, the state prosecutor's needs, which is post-election and going after bad actors, but it also allows the flexibility for the state administrator, myself, to address the more immediate needs to combat dis and misinformation with deep fakes, to not having voters get disenfranchised. So it allows me to correct the record in a quick and timely fashion. And so I think that this approach here addresses both, making sure voters are not persuaded or the deep fake is not successful initially, because we can't undo that impact if they don't vote. So thank you.
Thank you. And I believe we have one virtual favorable, Mr. Craig Holman.
Successful initially.
Okay.
We can't undo
Mr. Holman, if you could
that
please
impact,
mute
if they
or
don't
turn
vote.
off your streaming of the committee for the back. Perfect.
Yes.
Good afternoon. You have 2 minutes.
I'm Craig Holman, representing Public Citizen. We have roughly 16,000 members in Maryland. We are in support of HB 145. I've seen a number of deepfakes in the last election cycle, and it's alarming that they are virtually indistinguishable from reality. They can make candidates or people say or do things that they never, ever did, and they weren't even there. And there's no disclosure requirements, no regulation in election law, no chance for voters to be told that, hey, this isn't real. HB 145 would address that for Maryland voters is head on, quite frankly. It's that type of regulation is very popular. I've submitted written testimony that also cites polls showing that this is exceedingly popular regulation among voters of all partisan persuasions, Republicans, Democrats, and independents. And don't count on Congress to step in and help address this problem. Here in Washington, D.C., big tech really runs the show. So Congress isn't going to do anything to help voters in this area. It's up to the states, and the states are taking the lead on trying to regulate this. More than half the states across the country have passed some sort of deep fake election laws to help regulate this and help give voters a chance to not be tricked or fraudulently lied to by deep fakes. HB 145 would pursue that, and I strongly encourage Maryland to join the other states in regulating deepfakes. Thank you.
Thank you, Mr. Holman. Delegate Wu, I know you were first in line.
Thank you, Madam Chair. And I have a quick question, but I don't know who will be the best answer. Last night I looked at the physical note. I noticed the punishment is $5,000, up to $5,000, or up to 5 years. I was thinking about, because the AI tools are now so readily available, right? If some kids just want to play with some AI tool, to mimic something for election related, anything they post online probably will influence one or the other people. And I'm wondering, this kind of unintentional, maybe deep fake, right? And they're not intending to persuade somebody to vote this way or the other way, but the consequence can be dire. I'm wondering, how do we prevent these over-criminalized people who may just want to play with technology?
And so, we as prosecutors have to navigate this tension all the time. I'd say sort of this bill really doesn't criminalize somebody making a joke. This has to be AI to impede an election. So it wouldn't be something funny about the election, or it wouldn't be like somebody trying to do something satirical. But I understand what you're addressing, which is sort of, there has to be an investigation as it relates to intent. We have to do that on pretty much all of our, we always have to prove intent in our trials. And so that's something that we'll have to navigate. But the reason we sort of narrowed it to this element of the elections is that it's not including kind of candidates, parodies, those types of things. This is really about misinformation to voters about an election that looks real. So this is less sort of the parodies and things that we see. But look, we have all kinds of, and this comes up in revenge pornography, this comes up in a lot of sort of our digital cyberbullying, where we have to assess, how it should be applied to a specific case, and we'll always make that assessment. But we really did narrow this to be about election suppression.
Thank you.
Thank you. Delegate Tomlinson and then Delegate Ruth.
Thank you, Madam Chair. Can I have two questions? Okay. All right. First question. I know we keep talking about deep fakes, but see the language says including a deep fake. So it doesn't have to include a deep fake, right?
In what sense it doesn't have to include a deep fake?
I'm saying for the Board of Elections administrator to pursue this, it doesn't have to include a deep fake?
No, it can be using AI. That's correct. Right.
Okay.
Yes.
Yeah. And then I just wanted to run a scenario past, and I'm trying to make sure I understand. So this would not apply for if somebody, if, I don't know, Joe Blow goes on Facebook and posts a video going on, ranting about don't do mail-in ballots. It's full of fraud, all that kind of stuff. That would not apply in that case.
So
or would it?
This is not about sort of people's opinion about the elections, and that's a really good question, because I do want to differentiate that. So this wouldn't be sort of like mail-in ballots are dangerous. This would be like images of mailboxes on fire, and the government is burning your ballots. This would be images of sort of, again, someone like the governor or Mr. DeMarin is saying, we're not counting any of the mail-in ballots this year. This is about something that is untrue or fraudulent. It's not an opinion issue. If you don't think that the election is being done well, I'm sure Mr. DeMarin hears that quite a bit, with deep fakes or not. That's protected. That's a criticism. This is about something that looks real, and that's why it's in a different space.
And Delegate, it's already in the delegates already in the definition here about what actually is for mis and disinformation for electoral purposes here. It's time, place, or manner of an election, election results, voting rights. So it's like saying the election is on a Tuesday, on a Wednesday, not on a Tuesday. Things that would purposely try to disenfranchise, not opinion.
Okay. And if somebody took that, if the same rant from the random guy, but they put your face and your voice on it, that would certainly.
So that would still be an opinion.
Well, it depends. I mean, is it with a sombrero hat? Because then, I've already had that done. So
from personal experience.
But to answer the question, it wouldn't be something like Mr. Damaris saying something that Mr. Damaris simply didn't say. It would still have to fall into this category, right? So there's a separate piece of legislation that's gone through the Judiciary Committee that deals with identity fraud and the use of AI in identity fraud, which is a separate sort of space as applied to an individual, use of an individual's voice, et cetera. This is as applied to an election. So simply using Mr. Damaris's image or voice is not satisfactory for this legislation. The separate legislation, we could talk about sort of the spaces where it would constitute identity fraud.
Okay.
All right. Delegate Ruth.
Thank you, Madam Chair. And the same question I asked before, just wondered if you could address how you would even, I mean, these things are getting better and better, how it could even be detected, or I guess if Mr. Damaris says, I didn't say that and this is out, how you would, as an investigation, identify that it really was a deep fake.
So I think that it's important to divide that answer sort of as the legislation is divided. The first part of the legislation is to stop the dissemination of false information. That's what Mr. Damaris has the power to do. So if the information, let's say the AI is images of ICE officers at a polling place, ICE officers are standing outside this polling place, don't come to this, or, the verification is the factual truth that the people are not there, right? That's going to be enough for Mr. Damaris to go into court and say, stop the dissemination of this. This is false, right? And we can show that it's false because we are here observing it. This is not what's happening. This polling place is not on fire, et cetera. Or to your point, Mr. Damaris did not say that. Governor Moore did not say that. The second part of it, though, is our office's space where we have to engage with, whether it's the FBI or the state police, to actually have somebody, one, identify the person that created it, or the individuals that knowingly disseminated it to find its origins, and then prove in court beyond a reasonable doubt that it is AI. That's a separate analysis. That's why we did it this way, though, because the important thing is we do want there to be accountability when we find the individuals. We don't want this to be something where there's not accountability, but the immediate need is, if this is the morning of Election Day, it needs to be taken down that day. Our investigation is not going to be done in 45 minutes. So that's sort of the divide there.
Thank you.
Thank you. Delegate Solomon.
Thank you, Madam Chair. Delegate Feldmark, thank you for bringing this bill, and I appreciate you all being here. Just a question. Would you be open to adding, there's a number of states that have done disclosure provisions as well that require any sort of AI-generated fake videos that pertain to political content to be labeled as such, that there's some disclosure of that. Curious if you'd be open to something like that, or if there was a deliberate decision not to include something like that in the bill.
I'll share my thoughts, and if anyone else wants to chime in. For this bill specifically, I don't think a disclosure requirement makes sense, because if you're requiring a disclosure, there's a tacit allowing it to exist in the first place, right? I know there are, disclosure thoughts on where a video can't be prohibited for constitutional reasons. Maybe we can at least get a disclosure, and that will let people know that AI was used. But for this bill, I don't think that makes sense, because we're talking about speech that is not protected. So I don't think a disclosure makes sense to me.
So I can kind of address that there, because the people that are going to engage in mis and disinformation, especially on election results and voting rights, are not necessarily the ones that are also going to be good actors enough to put a disclosure on it. As we've gone into this realm of disclosures, the it's a very fine line as to, we've always had the ability to Photoshop and alter some images there. And so it becomes, how do you draw that line as to what is completely generated that would be AI or deepfake, and that is currently kind of used in the space. Right now, we do have some regulations already for political committees that would disclose something that if they altered a video or an audio recording, that this basically says that it is not, that did not occur in reality. So we do already have it under our authority line of delegation of powers, and we've made regulations to that effect there. But this one here, I think is fine as is without that, because it gives us the immediacy and the post-election process as well.
No, that's helpful. I didn't know that we already had those disclosure requirements, so that's great to know. Thank you.
Delegate Fisher, I think you have a question for us.
I do.
Okay.
It's a brilliant one, of course. My question is, and I've read the bill, I've seen the bill before, of course, and I know it's kind of been refined over the years. So it says the section does not apply, what page are we on here? It is page 3. Line 18, it starts there. This section does not apply with respect to a deepfake that is satire or parody. I guess my question is, how do you define that?
So that's a First Amendment definition term. And again, there's sort of two elements to this that are important to understand. Since we are sort of talking about the creation of an image.
Real quickly, it's a First Amendment define. It is? I mean, tell me, because it seems like you're micromanaging it here. So, it's like.
So we're not micromanaging it, we're excluding it. I'm going to just bifurcate in this explanation as to why it has to be in here and then what it constitutes as applied. So when you're drafting a piece of legislation that has First Amendment implications, excluding satire or parody makes the bill on its face survive constitutional scrutiny because it's excluding satire or parody on its face. That's a facial challenge to a law. Then there's what I think you're asking about, which is an as-applied challenge to a law, which means this is as applied to X situation. And that's when that is a defense that someone can raise if they're prosecuted for anything that implicates some type of speech. So the answer is, there would be evidence surrounding an investigation regarding the creation of something like this, and a defense could absolutely be raised that says, well, I was doing it as a joke and I was being satirical, and there would be potentially text messages, communications, context, and how it was posted that we would use to show whether and if the prosecutors believed it was not or whether they believed it was. That's how we evaluate intent. And so satire parody, I can see many examples of where if somebody was trying to make a joke, but that's something that they can sort of assert as applied to them, but it's excluded from the statute facially so that we can have that First Amendment protection as the bill exists.
Have you ever prosecuted someone that said it was satire or parody? And you disagreed?
In our sort of prosecutions on election law, it's generally not satire or parody that's the raised as applied. It's the right to be anonymous or the belief in sort of an invalidity of the election laws or an exceeding of transparency. They're normally not arguing that it was satire, but we're again prosecuting election laws as it relates to sort of fake robocalls, lack of authority lines, things like that. And so in sort of the First Amendment satire parody space, that's going to be something that we're going to have to evaluate with this statute.
You're going to have to evaluate it.
We always have to evaluate whether something falls into a First Amendment exemption, yes.
Got it. Thank you.
Delegate Oh my God, forgive me. Delegate Schindler. I'm so
Thank you.
sorry, Delegate.
Thank you, Madam Chair. With the nature of how quickly information spreads online, specifically with this type of a deep fake or a social media post or what have you, well, what's the confidence that you have, because the time-sensitive nature of something like this right before an election, say, or on election day, what's the confidence that you think that something like that could be neutralized in a quick manner?
It really depends on, that's just something that we can't answer as a generality. I will note that it also gives, and I'll let Mr. Jamarinis speak more to it, where it's sort of distributed and how it's distributed is going to dictate a lot of that. But this also gives Mr. Demarinis the ability in the State Board of Elections to counter it. So actually to put out accurate information, and if you want to speak more about that.
Yeah, so I think that's why this bill is unique in a sense, because it's not just going after the bad actors after the fact, because then a person who was influenced by the deepfake or the misinformation just wouldn't vote. This is actually being proactive in a sense by allowing me the ability to counter that speech with more speech to those people, because I will have subpoena power to get those records from those entities so I can know who I'm speaking to in a quick manner. And then at the end of this, if we have determinations on those bad actors, we can actually then go after them and say how much money it cost me extra to counter that speech. So that's why this is excellent in a sense, because it bifurcates it, because it allows the state prosecutor the post-election portion of it to go after them and to see if there's criminal activity. But for me, it goes with my mission, which is the immediacy and making sure voters are voting and having the correct information. And so that's why I think that this kind of worked out well in drafting.
Sure, if I may, that first portion of the bill, the counteracting of the misinformation, is a component of that also to try to get that taken down if you're able to?
Oh, yes, yeah, okay. Right. That was like, so right. It's, it's not just, I don't keep it up forever. I like, right.
Perfect. Thank you.
So, yeah.
Thank you. Okay. Thank you very much. So seeing no more questions for the favorable panel, thank you for presenting the bill. You're excused. We'll now move on to the favorable with amendments for HB 145. We have Megan Stokes, Grayson Wiggins, and Rebecca Snyder. And I believe joining us virtually, we have Mr. Cost. And you guys can duel over who will go first. Feel free.
All right.
Ms. Snyder.
Well,
2 minutes.
Thank you, Madam Chair and Committee. My name is Rebecca Snyder. I'm the Executive Director of the Maryland, Delaware, D.C. Press Association. It's a delight to be in this new committee. And we, of course, we support the goals. No one wants deepfake or misinformation, disinformation infecting our elections. However, our amendments really center around news media. In the latter part of the bill, we were exempted from some of those pieces. We want the news media exemption to be in the first part of the bill. Our members publish paid advertisements and other related content during the election cycle, and we want to make sure the focus stays on the bad actor without sweeping news media into this. We have worked with the State Board of Elections and the Senate sponsor to get amendments in, and we just want to make sure they're mirrored in the House. So we do support the outlines of the bill, but we want to make sure those exemptions in the amendments stay in place. Thank you very much.
Thank you, Ms. Stokes.
Good afternoon, Chair Wells and members of the committee. My name is Megan Stokes, State Policy Director at the Computer and Communications Industry Association, also known as CCIA. I'm going to be very quick, but probably not as quick as she was. So we agree that individuals who intentionally create and distribute deceptive political content should be required to provide clear disclosures. The state should be able to respond quickly. And that we also think that well-designed guardrails can help to protect Maryland voters while preserving free expression and innovation. To achieve that balance, it's critical that HB 145 limits liabilities to the bad actors themselves, the individuals who create and then knowingly disseminate that deceptive content. For that reason, we urge the committee to ensure that the bill aligns with long-standing federal framework under Section 230 by explicitly exempting interactive computer services, internet service providers, cloud providers, and telecommunications networks from liability for that third-party content. We also recommend adding clear cybersecurity and anti-fraud exemptions. Security teams, fraud analysts, researchers, and law enforcement must routinely collect and analyze deceptive media to protect the public, to preserve evidence, and disrupt criminal activity. Without clear exemptions, those good faith efforts could be chilled, and making it easier, not harder, for bad actors to evade detection. With those targeted amendments, House Bill 145 can more effectively combat deceptive political media while remaining consistent with federal law, other states who have also enacted their own synthetic media law, and preserving critical protections for innovation and security. Thank you for the opportunity to testify. I look forward to continuing work with our committee.
Thank you very much. And we are gearing up virtually to hear from Mr. Pearson Cost.
Good afternoon.
Good afternoon.
My
You may
name is
begin.
Pearson Cost, and along with Tim Nelson, I serve as counsel to the Maryland, D.C., Delaware Broadcasters Association. The association requests that the committee amend House Bill 145 to account for television and radio broadcasters who are already working diligently to protect against generative AI, distorting the news reporting and informational content that they source, produce, and freely deliver to the public. MDCD is concerned that the exception for when a broadcaster has been paid to broadcast the deepfake is undermined by also requiring such broadcaster to have made a good faith effort to establish that the deepfake is not a deceptive and fraudulent one, because the standard is ambiguous and focused on undefined actions. The amended version of Senate Bill 141, the Senate companion piece, incorporates the amendment you see in Exhibit A to our written testimony, and we are hopeful that this committee will similarly remove this standard. From what it sounds like, the conforming amendment may do just that, and we would strongly support such an amendment. Regarding Section 2-110, the association does not believe that a broadcaster in receipt of paid advertising that contains misinformation should be subject to state action or forced to shoulder the burden of investigating each paid advertisement or program for content that appears to be realistic but is in fact misinformation. MDCD respectfully requests that the broadcaster-related exceptions found in Section 16-905 be incorporated in this section, as shown in our written testimonies, Exhibit A. The additional amendment proposed by Delegate Feldmark may address this, and we thank the committee in advance for considering it. Thank you.
Thank you. Are there any questions for the panel for favorable with amendments? Okay, seeing none, we will move on now. We have one unfavorable, Frank Boston. Come on down.
I kind of feel like the odd egg here. I really don't want to be unfavorable, but you should have a box like unfavorable unless amended, you know, and we don't have that box. So anyway, I am Frank Boston. I am here on behalf of DirecTV and Dish. And thank you, Delegate Feldmark, for putting the bill in. The amendment that the sponsor was speaking out, our amendment was already adopted in the Senate. We have written testimony that has been submitted to this committee on behalf of both my clients. Also, written testimony has been submitted by my partner, Ari Plout, explaining the amendment. And that's actually, we have two amendments. That's the first amendment. And the explanation for the First Amendment is, it basically said that the broadcaster would only be exempt, and it said, and I'm looking at page 4, the broadcaster has been paid to broadcast a deep fake, and here's the part that we had exempt, and we would like this committee to also exempt, made a good faith effort to establish that the deep fake is not a deceptive or fraudulent deep fake. And the reason why we wanted that exempt is because we are not the contracting party to the payer of the ad. All we do is run the live feed that is given to us from ABC, NBC, Fox, or whatever. So there's no way possibly that we could make any type of effort, a good faith effort or any type of effort to establish that the deep fake is not deceptive. So the Senate realized that it's impossible for us to do that. You know, it's just like, you know, an ad that says the Chevy Tahoe gets, 24 miles to the gallon. There's no way for us to know. We just run that ad. The Second Amendment, I only have 4 seconds, basically says, if you allow it, it's only 2 words.
How about I ask you a question? What does the Second Amendment do?
Second Amendment? Huh?
To the bill, thank you.
Oh, yeah, the Second Amendment to the bill says, it just adds the words, it lists, all of the people who it doesn't apply to, and it says satellite television operators, programmers, or producers, and its affiliates is the language we want. Because we have streaming companies with the same argument applies And so they are affiliates of the companies that are exempt. And we'd just like to add those 3 words.
All right, thank you, Mr. Boston. Seeing no questions, this concludes the hearing on HB 145. All right, next we will be joined by Madam Chair Wilkins for HB 115. And if your sponsor panel could come up, I know that you have to leave for a meeting, so I want folks to know that she's not leaving rudely. She has to attend to a meeting with the speaker.
Thank you so much, Madam Chair.
Thank you for your patience.
I appreciate you. Thank you. Hello, Mr. Vice Chair, and greetings to everyone on the Government, Labor, and Elections Committee. I also want to personally thank you all for your stewardship over election law, an issue near and dear to my heart, and congratulate the subcommittee chair. For the record, I am Delegate Janelle Wilkins, and I'm pleased to present House Bill 115, Election Law Individuals Released from State Correctional Facilities. Over the last decade, Maryland has taken meaningful steps to expand access to the ballot. We've restored the right to vote for Marylanders who are incarcerated and returning to our communities, and ensured that voting is treated as a fundamental right, not a privilege. I, as well as my panelists, have championed voting access for people who are incarcerated and those returning home because their vote is their right, and they are among those with the least access to that right. As you know, when an individual begins incarceration for a felony conviction, the State Board of Elections receives a list of those individuals and cancels their voter registration. Since 2016, Maryland law has been clear that the right to vote is restored immediately upon release from incarceration. So again, we have settled law that upon release from incarceration, individuals, it has the right to vote. But there is a problem. While we cancel their voter registration at the start of their incarceration, we do not proactively restore their voter registration. We turn the lights off, but we never turn it back on. People leaving prison face enormous reentry challenges. They're focused on securing housing, finding employment, accessing healthcare, and reconnecting with their families. We can reduce a barrier, which is a barrier of civic engagement and voting, by reactivating their registration, which is a right that the state has already restored. House Bill 115 requires the State Board of Elections to reactivate voter registration for individuals who are released from state correctional facilities who were already registered to vote. Under the bill, Department of Public Safety and Correctional Services will share release information with the State Board of Elections so that individuals who were previously registered can be reactivated. House Bill 115 does not expand eligibility. It does not change who can vote. It simply ensures that the right to vote is real, accessible, and meaningful for those returning. I do have a couple quick notes on the bill. I have an amendment that I want to flag in working with the Department of Public Safety and Correctional Services. The amendment would just change the release information to be shared monthly instead of weekly, so it's a one-word change in the bill. I also want to note that regarding the fiscal note, in working with SBE, they actually are going to be upgrading their systems, and they have noted, and the administrator can confirm, sitting right next to me, that if we push the effective date back just a few months, they will have the technology and therefore substantially reduce the fiscal note so that won't be an issue. As was mentioned, I apologize that after questions, I'll have to depart for a meeting, but thank you so much, and I urge a favorable vote on HB 115.
Thank you so much. Madam Chair, we will move to, I think I have Trina Selden and I have Ms. Antoine. Okay. Ms. Selden.
Hi, good afternoon, Chair, Vice Chair, and members of the Government, Labor, and Elections Committee. My name is Trina Selden, and I am the founder and executive director of Out for Justice, a community-based organization dedicated to engaging, educating, and empowering people impacted by the legal system to build collective power, reduce recidivism, and dismantle harmful exclusionary policies. I submit this testimony in strong support of House Bill 115. For nearly 2 decades, Out for Justice has worked to advance fair elections, protect access to the ballot, and ensure that communities historically excluded from civic life, particularly returning citizens, Black communities, and low-income residents are fully able to participate in our democracy. So when I came home from prison in 2003, reentry felt almost impossible. One of the most devastating losses I experienced was the loss of my right to vote. Even after completing probation and all these wonderful programs that they asked me to do, I was misinformed and denied the ability to register. At a time when I was rebuilding my life, I was not recognized as a valid participant in the democratic process. That experience is why I founded Out for Justice in 2006, to challenge the dead injustice impacted people face, to restore dignity, voice, and opportunity. Our work helped launch Ban the Box in Maryland and pave way for reforms like Value My Vote Act, restoring voting rights to tens of thousands of Marylanders. These victories share a simple lesson. People succeed when systems are designed to include them, not exclude them. HB 115 applies that lesson, my glasses, okay. HB 15 applies that lesson in practical and common sense way. The bill requires that the Department of Public Safety and Correctional Services to release information to the State Board of Elections so that individuals who are previously registered to vote have their registration automatically restored upon release. I urge a favorable report. I got a whole bunch more.
We'll keep an extra pair of glasses up there next time.
I know.
It's okay. Thank you for your testimony, Ms. Antoine.
Yes, good afternoon, Chair Wells and members of the committee. For the record, Joanne Antoine, Executive Director of Common Cause Maryland, and I am testifying in support of House Bill 115, which would ensure all eligible voters, including those who are coming back home from correctional facilities, that they know that they are eligible to vote and that they have meaningful access to voter registration. Now, as Delegate Wilkins said, we restored the right to vote for those coming back home in 2016, and in 2021, we passed bipartisan legislation that ensured that eligible voters who are incarcerated right now, that means those who are on pretrial serving time for misdemeanors, that they have a process for voting behind the wall. Now, that legislation has been great. We've seen it implemented, but it didn't go too far, right? When a person is coming home, they are handed a paper registration form in their packet. Now, just as any voter, you could imagine, right, you are not going to go out of your way to mail your voter registration form or go to a board of elections to drop it off, right? So again, this helps to ease that process and remove some of the barriers that folks are facing when they're coming back home. And as Trina had said, you know, when people are coming home, they're confused, right? They're receiving a lot of misinformation, whether or not they're in fact eligible to vote, whether or not they can go and register. If I go on election day, can I use same-day registration? You know, this addresses all of that. The only other piece I wanted to add, you know, we've worked in coalition. We were able to visit over 17 correctional facilities during the 2022 election cycle. You know, we've seen folks inside of all political affiliations actively registering, looking for information, and voting their ballots. We saw that here in Anne Arundel, where we have Marcia Savage, who I believe is testifying later on, who can highlight the progress that we've made inside. So there's robust outreach and engagement happening. It should not end when the person is coming home. So, you know, this is good legislation. We know that if we want a participatory democracy, it includes everyone, and I would urge a favorable report. Thank you.
Thank you. Mr. Demarinis, are you here for?
Just for information, so
All right.
no questions, yes.
Great. Do we have any questions for the opening panel? Delegate Schmidt.
Thank you, Chair. I do remember this bill, maybe last year in Judiciary. I don't remember. Did we talk about,
yeah.
My question would be, do they re-register back where their original permanent residence was, or is it where they're currently living? I somehow remember this bill. Maybe I dreamt about it. I don't know. But somehow I remember it.
That's a great question. It was primary in Ways and Means, but perhaps it was jointly assigned. So we might have been listening to it in committee. That's a great question. Department of Corrections and Public Safety has indicated that about 180 days before an individual is released, they start to the reentry process, and they identify where the person will be living, their address, and so they obtain that information for those who are returning. So they would be registered at that location where they will be returning to their communities.
All right. Thank you for that answer. I don't know if I didn't catch it if you guys said it earlier, but thank you.
I don't think we did, so
Okay.
thank you.
Awesome. Thank you.
Delegate Chisholm.
Thank you, Madam Chair. Thank you for bringing the bill. I have a question. I know in the bill it says they can opt out, but after the fact, but it looks like they're automatically registered. You were just speaking of the 180-day, I guess, pre-time frame. Could you give them an opt-out at that point, or do you feel like it's better to just automatically register them and then have them have to take another step to opt out? There's reasons why people might want to opt out, obviously, but just
That's a great question, Mr. Chisholm. I think that because these are individuals who were already registered to vote coming in, and because of our laws, we have canceled their voter registration. I do think that taking the step of then returning them to that status of being registered, and then if they would like to opt out, they do receive information that they've been re-registered. That I think that that's a fair step, but certainly this is before the committee, and if that's a step that you would like to take, I think I would respect the decision, but these are individuals who were registered before.
okay. Thank you.
Thank you so much. Okay, seeing no more questions for the opening panel, thank you to the chair and thank you to your panelists. We will move on with additional favorable testimony. I have Martin Mitchell, Antoine Quarles, and I also have Nikki Tyree and Yeshua Downey.
Pause that.
And Nicole Porter. I think those are all of the individuals here to testify in person. Say that again? Virtual? Or, okay, all right, I'll make a note. With that, we will begin with Ms. Nicole Porter. And just a reminder, it's 2 minutes for testimony. Thank you.
Yes. Good afternoon, Chairman Wells and member of the committee, Chairwoman Wells and members of the committee. I am Nicole Porter, Senior Director of Advocacy with the Sentencing Project, which is a national research and advocacy organization based in D.C., and I'm also a Maryland resident. I've submitted written testimony, and but want to focus my comments today on the public safety benefits of this legislation. There is a community safety benefit to guarantee the vote to persons with past incarceration experience. Voting is among several pro-social behaviors for the legal system impacted persons, like getting a college education that is associated with reducing future contact with the criminal legal system. And having the right to vote or voting is related to reduced recidivism for persons with a criminal legal history. Maryland is among several states, as we've already heard, that ban voting for persons with a felony conviction while allowing others to vote in the community. HB 115 would continue Maryland's leadership in guaranteeing voting rights for certain marginalized communities. And Maryland is among 26 states in Washington, D.C. that has expanded voting rights to persons with felony convictions since 1997. And among the reforms in Maryland has contributed to over 2 million people getting their voting rights back nationally. So part of the steps to guarantee those rights through this legislation would align Maryland with states that have taken similar steps in recent years. Just last year, Washington state lawmakers adopted Senate Bill 5077 to allow the governor, in partnership with the Secretary of State, to authorize automatic voter registration at designated state agencies, creating a legal pathway for county jails and state prisons to automatically register incarcerated residents to vote. Similarly, Michigan created similar legislation earlier, a few years back. So with that, the Sentencing Project thanks you for your consideration and urges a favorable report of House Bill 115.
Thank you. And so I apologize. I'm not sure if that's Mr. Downey or Mr. Quarles. So if you could please state your name. We can just move down the line. So this gentleman here.
Okay, thank you.
Yes.
Yeshua Downey, thank you. On behalf of Campaign Legal Center and at the request of Common Cause, I'm pleased to submit this testimony in support of HB 115. And as someone who was born and raised in Maryland, has a large family in Maryland, and with a past felony conviction myself, this bill hits home for me. Like I said, I'm Yeshua Downey. I'm with the Restore Your Vote team. I'm the organizer at Campaign Legal Center's Voting Rights Program. We're a nonpartisan nonprofit based in D.C. that works to protect and strengthen democracy across all levels of government. And the Restore Your Vote program helps restore voting rights to people with past felony convictions by providing direct rights restoration services and empowering community leaders to understand and monitor implementation of rights restoration laws. Voter registration process is one of the most significant barriers to voting in the United States, and this is particularly high for formerly incarcerated voters. The rules for voting after a felony conviction are confusing, and like I did for many years, too many individuals believe a felony conviction is a lifetime ban on voting. I'm not exactly sure where I first learned this misinformation, but I have missed plenty of elections not knowing that I was eligible. I've had friends argue me down, swearing to God, putting it on their mama, telling me that I cannot vote with a felony. In Maryland, your right to vote is restored after release from incarceration, and this bill will help activate that right and ensure that people are registered with minimal effort and without any extra hurdles. HB 115 will make the process easier for formerly incarcerated residents, lowering the registration barrier and encouraging participation for people who are eligible. And yeah, our democracy works best when everyone can participate, so this bill would be a huge step forward. Maryland would be a leader in rights restoration as one of the few states to implement auto registration upon release. Thank you for your time.
Thank you. With 1 second to spare. Awesome job. Mr. Quarles. Am I pronouncing your last name? Okay,
Yes.
perfect. Thank you.
Good afternoon to everyone, Madam Chair, and the whole committee. My name is Antoine Quarles. I'm a founder of Hope Baltimore, Helping Oppressed People Excel, which is a support to reintegrate formerly impacted people once they're released with support and measures of understanding their citizenship. Based upon this, I support House Bill 115 is because basically around when I got released in 2013, I was told I couldn't vote. And then basically becoming a member of Alpha Justice and battling and learning a lot of misinformation that we found out ways of reintegration was happening through restoring these processes. And now we continue as a network to help those behind the wall, those outside the wall, their families, educated in community discussions, because so many people just don't understand what their right is. Questions have came, what's the difference between being a people and being a citizen when things are being disenfranchised from you. Looking at measures that I always try to say that Maryland has been real restorative in helping this process, but then it still is disenfranchisement that hold burns on us around this. And while those inside, I always say, like they got a sentence, but the right to vote is just their human right. It's not something that should have been taken from them or given to them, because I know it is quotes to say no one can like debar you from anything of being a citizen or playing a part of your community. But then they out of a community, but they living in a community. So they still have family that's in the community. So I think this bill will help educate and restore these things from both sides to be citizens and liberate that community at the end to show that they're playing a part, though they're away from the community. And that's what my point, just being as a lived experience person.
Thank you very much, Mr. Quarles. Ms. Tyree, we're becoming best friends already.
I said I'm going to be up here for 2 more after this. Lucky. Okay, so again, for the record, I'm Nikki Tyree, Executive Director for the League of Women Voters of Maryland. The League believes that HB 115 is a much-needed restoration process. As a League, it is very common for many of our members to go into facilities to discuss and help those incarcerated get re-registered to vote and ensure that they are put back on the rolls. Oftentimes, we are told that they are given voting information as part of a large stack of papers, and if not for the volunteers, they would not get any information at all, going so far as to be told by staff that they wish that they were not there to do it anyway. With the passage of this bill, the right to vote will be restored, ensuring that all those who are eligible will have the right to vote. HB 115 speaks to good governance by allowing interagency communication, improves the processing of re-registering while reducing voter frustration, and ensures accurate voter rolls. As you've heard, when our citizens are coming home, they are dealt a lot of cards. We just believe that this is one that can be streamlined into a process. Thank you.
Thank you. Okay, so we're going to move on to our virtual witnesses. But I want to thank you to all those that were able to testify in person. We will begin with Mr. Christopher Cano.
Thank you, Madam Chair.
SAU Local 500 represents tens of thousands of public service workers across Maryland who believe adherence to democratic principles and civic participation are the duty of all Americans. And this bill is a common sense and overdue step to ensure that Marylanders who are legally eligible to vote after release from incarceration are not disenfranchised by bureaucratic barriers. Under current practice, too many returning citizens leave state correctional facilities with their voting rights restored in theory, but not in practice. And this bill closes that gap by creating a clear, automatic process to restore voter registration for individuals who were registered prior to incarceration and who reside in Maryland upon release. Now, our members believe that democracy works best when participation is accessible, inclusive, and fair, and workers understand firsthand how administrative hurdles can quietly deny people their rights. This bill recognizes that restoring the right to vote should not depend on navigating paperwork during an already difficult reentry process. Automatic restoration ensures that eligible voters are treated with dignity and accuracy, not suspicion or delay. Importantly, this legislation also protects an individual's privacy by prohibiting disclosures under the Public Information Act of the fact that a voter was registered through the Department of Public Safety and Correctional Services. That safeguard matters. It prevents stigma, retaliation, or misuse of sensitive information, and affirms that once someone is eligible to vote, they should be treated no differently than any other voter in Maryland. Our members include school employees, public servants, and higher education workers who see every day how civic engagement strengthens communities and workplaces alike. When returning citizens are fully reintegrated into civic life, families are more stable, communities are safer, and democracy is stronger. This bill aligns Maryland law with those values, enabling our state to be the example for representative democracy rather than what we are seeing in other states across the South right now, such as Florida, that continues to put hurdles in place for returning citizens, thus stifling civic participation. SCU Local 500 urges this committee to advance House Bill 115 and continue Maryland's leadership in protecting voting rights and promoting inclusive democracy. And we'd like to thank Delegate Wilkins for leading on this important issue. Thank you for your time.
Thank you, Mr. Kano. Mr. Mitchell, you're next. You're on mute, Councilman Mitchell. Okay, there, yep. You may begin, give 2 minutes.
Okay, thanks. Greetings, Chair and distinguished members. I appreciate you for taking up this issue. My name is Martin Mitchell. I'm the former at-large councilman for the city of Laurel and an active NAACP member. Today, I'm here as a dedicated advocate for criminal justice reform and a community organizer with Life After Release. Life After Release is a Prince George's-based reentry organization that supports our brothers and sisters returning home, and some while still inside through court support, Court Watch PG, mutual aid, and providing real community and real resources and real pathways forward. HB 115 is simple. When people are released from incarceration, their voter registration should be automatically restored, not delayed, not buried in paperwork, not treated like a privilege, automatic. Because if someone has served their sentence, they have served their sentence. They should not walk out of the correctional facility still carrying a civic punishment that follows them for years. I've canvassed across Prince George's County time and time again, and I've met brothers and sisters who have no idea that their voting rights were restored back in 2016. Not because they don't care, but because nobody told them. And the system is not designed to make it easy. This is a failure of policy. Voting is a cornerstone of democracy. Automatically restoring voter registration helps establish a relationship between returning citizens and the political community. It says you belong, you still count, and you still have power. Let's be honest, our criminal legal system has fallen hardest on Black and brown communities. When we place extra hurdles in front of returning citizens, we are not protecting democracy, we are shrinking it. Returning citizens are counted in the census. They are subject to laws. Many pay taxes, yet too many remain locked out of choosing the leaders that will shape their lives. It is our chance, Maryland, and we have an opportunity to lead again. I urge a favorable report of HB 115. Thank you.
Thank you, Mr. Mitchell. And I just want you to know that we all were delighted to be joined by your additional testifier behind you during, they made it known that they support the bill as well. So that future voter. But thank you so much for, thank you very much. And I just wanted that, Are there any questions for this panel? Okay, seeing none. I also don't think I officially thanked the previous panel for coming down to testify, so I want to extend my gratitude and thanks for you coming down to speak on the bill. With that, that ends the bill hearing on HB 115, and we will now move on to our next bill, Delegate Foley, HB 50. And Delegate Foley, do you have a panel? You have a
I
panel,
do,
correct?
Madam Chair.
Okay.
One of my panel members is ill and submitted written testimony.
Correct. Yep.
But I
made
think
a
I
note.
have two more people.
Yes. I have Miss, wait, Joanne Antoine. Okay, I think these names.
And
I'll let you tell me who it is.
Okay. I have to look.
We'll go through everything.
Okay. All right.
Okay. All right. We have a bunch of people testifying in favor. I don't care, you know,
The order.
who comes up with me.
Understood.
Anyway, thank you, Chair Wells, Vice Chair Kerr, and members of the Government, Labor, and Elections Committee. And I bring greetings to all of you E&T alums from the Environment Transportation Committee. I'm Delegate Linda Foley, and I'm presenting HB 50, General Assembly Special Election to fill a vacancy in office, which would allow Marylanders to vote on a constitutional amendment to change how legislative vacancies occurring during a 4-year term are filled. Many of you are familiar with this legislation. This is not the first time that I brought it. Under current law, presenting HB 50. Are we good? Okay. Under current law, when a delegate or senator leaves office midterm, the county central committee of the departing legislator's political party recommends candidates to the governor, who then appoints a replacement to serve the remainder of the term. That appointment can last anywhere from 6 months to a complete 4-year term, or nearly a 4-year term, without voters having any direct say. As a result, more than a quarter of the 188-member General Assembly entered office through appointment rather than election, including myself, by the way. While appointments provide continuity, the current system limits democratic accountability for extended periods of time. HB 50 would inject more democracy and voter engagement in the vacancy filling process. If approved by the voters, the constitutional amendment would allow the governor's appointee to serve until a special election at the midpoint of the 4-year term held during the regularly scheduled presidential election, if a vacancy occurs 55 days or more prior to the candidate filing deadline for that election. Vacancies occurring more than 2 years into the term would continue to be filled by appointment only. This approach, let me stress this approach is a compromise. Holding standalone special elections throughout the year would impose significant costs on local election boards and likely result in low turnout that does not accurately reflect the will of the electorate. HB 50 combines the efficiency of appointments that we currently have with guaranteed voter input at least every 2 years during elections that are already scheduled and widely participated in. So, some statistics. Overall, 29 states have procedures to fill legislative vacancies that include special elections in at least some circumstances. Only 8 other states, besides Maryland, have a process similar to Maryland's, where the governor appoints the replacement for the vacancy. The history of the bill goes back years. This bill was first proposed in 2008 by Senator Richard Madaleno and, wait for it, then Senator Jamie Raskin, who was representing District 20, to advocate for more democracy and voter engagement. This is the 4th year I have put this bill before the General Assembly. Prior to my sponsorship, several other delegates and senators have proposed similar legislation in past years. Last session, this bill passed the Senate 44-2. This year, this bill, same wording, exact same wording, has passed the EEE committee in the Senate unanimously and is on 3rd reader, expecting to be taken up tomorrow in the Senate. This year, there is again a groundswell of support in Maryland for special elections to fill legislative vacancies. Without a ballot question on the appointment process this year, the change would not take effect. If we don't do it this year, the change would not take effect until at least 2032, and I don't think we can wait that long, since it must be approved by the voters before a presidential election. So I don't think we can wait that long. Let me also add that in years past, there has been some opposition to this bill. And I am proud to report that this year, there is an amendment submitted by Chair Wilkins of the Ways and Means Committee to co-sponsor this bill. So I just wanted to bring that to the committee's attention. For all of these reasons, I urge a favorable report on HB 50, and I'm happy to answer any questions you might have.
Okay, great. Before we do questions, I want to just finish up with your sponsor panel. So Mr. Bradshaw.
Yes. Sure. Lee Bradshaw, Maryland Forward Party. Hello again. Just to save time, I will say we agree with everything Delegate Foley just said.
Is that our first? With me too. Thank you. I was like,
Yes.
That's what they said. I couldn't
No
remember.
amendments, please
All right.
pass the bill.
Okay. Awesome. And is this Ms. Smith?
Yes.
Okay.
I'm not going to be as quick as him, but good afternoon, Chair and members of the Government, Labor, and Election Committee. My name is Lisa Smith. I'm an elected member of the Montgomery County Democrat Central Committee for District 14, and I strongly support House Bill HB 0050. When a seat in the General Assembly becomes vacant, voters lose their voice. Under our current system, that voice is replaced by an appointment made behind closed doors, with a single vote for the people who are supposed to be represented. That is not how democracy should work. HB 0050 fits this by allowing voters to elect their representative when a vacancy occurs early enough in the election cycle, using the existing primary and general election. It is fair, effective, and it restores accountability. Working people knows that representation matters. Leaders should be chosen, not assigned. I urge the committee to stand with voters, stand with democracy, and give a favorable report on HB 0050. Thank you.
Thank you, Ms. Smith. Delegate Lehman.
Thank you, Madam Chair, and thank you to my good friend Delegate Foley. Thank you really for your tenacity in working so hard on this bill the last several years. We've had many conversations about it. I have two related questions, Madam Chair, about the timelines you mentioned. Can you explain the relevance of the 55 days prior to the filing deadline? I'm not sure I understand that part.
Okay, thank you, Delegate, for that question. So, as I mentioned in my testimony, this is a compromise bill. Over the years, there were compromises made with respect to this bill so that it would, it could address concerns that were raised. One of the concerns that was raised over the years about this bill is because we have a prohibition against raising money for campaigns during the legislative session, that if we did not give enough time for these appointed people to raise some money before the prohibition kicked in, that they would be disadvantaged. So that's the reason for the 55 days, Delegate.
Okay, thank you for that. And then because I believe, well, at least in Prince George's, the rule on the law on special elections allows them to occur up through the end of the third year. And this is only for the first 2 years. Is it purely an issue of cost, the compromise you referred to? Is that what it's primarily about?
Yes, delegates, it's an issue of cost primarily, but I think there also is something to consider in terms of, we only meet every 90 days. We only meet once a year for 90 days. We don't meet year round. And so it's also, I think, an issue of turnout, that if you hold the special election when you're holding the presidential election, you're going to get a much more representative sample, if you will, of voters representing the electorate. But the primary reason is cost.
Thank you. Thank you for those explanations, and thank you again for your commitment to this issue. It's long
Thank you.
overdue.
Thank you.
Delegate Fair.
Thank you, Mr. Chair. Thank you so much for bringing forward the bill, Delegate Lehman. Let's take a look at the legislation here. Just a quick question for you.
Sure.
When it comes to, one of the things we saw this last 4 years specifically, was kind of the most extreme version of the appointment process and the process that we were seeing. Were you able by any chance, and I'd understand if you needed to go back and look into this and get back to us, but how many people would have fallen under the presidential year in 2024 under this bill if we had enacted this just 4 years earlier?
Just a second, Delegate. I don't think we have that. Huh? More than Justin? Yeah. We didn't do that calculation, but I'm told by my staff who did the research on this that it's more than a dozen.
Okay. Okay, that's great to know. Well, thank you so much.
I mean, Delegate, of course, as you know, most of the vacancies occur when the governor takes, begins a new administration and appoints people from the General Assembly, rightly so, right? I agree with that, to take positions in the administration. That's when we get the most number of appointments, but it's not all of them.
And you saw, I think we saw the kind of domino effect, appoint a senator.
Right, so you appoint a delegate or a senator, you appoint a senator, and then you have to have a delegate. Yeah, that all, exactly, the domino effect. Yeah, thank you.
Well, thank you so much for the time.
Thank you.
Thank you, Mr. Chair.
And Delegate Stewart.
Thank you, Mr. Chair. Thank you, Delegate Foley, for coming. It's great to see you. Thank you for your commitment to this issue over the years. I'm hoping this is finally going to be the year for this. I was just wondering if you could regale the committee with what the complexion looks like across the rest of the country. How many states have special elections? How many states have appointments? Where do we fit in with the national climate?
Yeah, thank you for that question, Delegate. And I did mention quickly in my testimony that there are 29 states that include some sort of special election in at least some circumstances, and only 8 other states have a gubernatorial appointment like we have. And I can go through those states if you'll just indulge me for, so the states that just have like purely special election are Alabama, Arkansas, California, Connecticut, Delaware, Florida, Georgia, Iowa, Kentucky, Louisiana, Maine, Massachusetts, Michigan, Minnesota, Mississippi, Missouri, New Hampshire, New York, Oklahoma, Pennsylvania, Rhode Island, South Carolina, Texas, Virginia, and Wisconsin. They have just purely special elections. The hybrid systems are in 5 other states, 4 of which include elections. So the 4, like we're talking about here. So the 4 that include elections are Colorado, Kansas, New Jersey, and Tennessee. So that's a total of 29 that includes elections. Hawaii has a hybrid process, but it doesn't include an election. Then the 8 other states that have gubernatorial appointments are Alaska, Idaho, Nebraska, North Carolina, South Dakota, Utah, Vermont, and West Virginia. And then there's some other variations of appointments and whatnot. One has a legislative chamber votes to fill the seat, that's Ohio. So that kind of gives you a complexion. But the vast majority, or the majority of states, have special elections.
Got it. Just one more question, if I could. One criticism that I've heard of this bill in the past, and I don't know if this is part of why it hasn't gone over here on the House side or not, is that appointments historically and empirically have provided a more diverse set of state legislators to join the body, whether that's racial diversity, whether that's sexual orientation, whether that's, a better gender.
Delegate, thank you for that question. First of all, let me point out that this bill preserves the appointment process. So whatever advantages there are with respect to that in terms of promoting diversity, it does provide appointments that then you have an incumbent like running for the seat, right? Who would, who was appointed by the governor on advice from the Central Committee. So I just want to point that out, number one. Number two, we did look at that issue. And I think that at some point in time, prior to, for example, our election of a African-American woman as Speaker of our House, and an African-American as Governor of our state, and an African-American as Attorney General of our state, and a woman as Comptroller in our state. I think at a time, years prior to that, that might have been the case, that our elections did not kind of produce the diversity that would reflect Maryland. I think, but when we looked at it, it no longer held that actually elections produced the same level, and in one case, in one election, like more diversity than the appointment process did. So I think that issue over time has become less dependent upon the appointment process. And I'm really proud of what we've done in the General Assembly, and I'm really proud of whatever processes we've had, because it has led to us having a diverse General Assembly that reflects Maryland. So I think whatever we've done a good job, but I think we no longer, I mean, we're in a position now where we can rely on the voters to participate in this process.
Thank you.
Delegate Terrassa.
Thank you, Mr. Chairman, and I want to welcome my ENT colleague. You explained why the 55 days, but can you just briefly explain how what it does in terms of the 55 days? Like, in other words, what does it say happens? And
It's just a cutoff for when the appointments would be subject to special election.
So 55 days from
before the filing date for the presidential general election.
And so what happens after 55 days?
It would just be an appointment.
And they would just run for election in
the regular cycle, yeah,
okay.
Just like it is now, yeah.
Okay, thank you.
Sure.
Can we bring up the virtual witnesses? Christopher Cano, Edward Fishman.
Mr. Chair, this kind of got sideways a little bit. Actually, the people on my panel, these are wonderful people up here, but they were not on my panel. My panel was actually folks over here. So we have so many people that want to testify in favor of this bill. I just want to point that out, that's all.
All right. So do we have any of the virtual witnesses?
I'll get out of the way.
Okay, so let's bring up the virtual witnesses, and then we'll bring up your panel.
Is that okay, sir?
Yeah, that's fine.
Thank you, thank you. I appreciate your indulgence.
Thanks for sorting it out for me.
Yes, thank you so much, Vice Chair Kerr. For the record, Joanne Antoine, Executive Director of Common Cause Maryland, testifying again in support of House Bill 50. I think the individuals who went before me summed up a lot of it already. I think it's an organization, we have been championing this special elections reform since 2008, right? We've had so many different iterations, and the bill before you right now is a compromise based on feedback that was provided by the House. So the 55-day period that's on there and so forth, that was the House of Delegates that provided those recommendations. So my hope is that we will pass the bill in the posture that it is and send it, make sure that it's on the ballot this November for voter approval. I did also just want to note on the diversity piece, right? Obviously, at the state level, we are very diverse. We've been able to have a lot of firsts. I believe, last year we had the first Mexican American, right, that was appointed. So we acknowledge, the progress that we've made. But from our understanding, and again, I don't serve on a central committee, the central committees do not have a process or parameters, in place where they are to kind of determine whether or not, if this seat is vacant, should we consider more women, right? Should we consider whether or not this individual ran for this seat and maybe came in fourth place and should be, should possibly get this appointment, right? So while, again, some of the jurisdictions, some of the central committees try to be intentional, again, it is not a requirement from our understanding whether or not, they're taking opportunities maybe to have, those who identify as different genders and so forth represented on the General Assembly. So I did want to note that. Again, from our understanding, Central Committee does not need to do that. So again, we'd urge a favorable report. Let's not discuss this for another 2 years. Let's make sure this is on the ballot this November. Thank you.
Thank you, Vice Chair Kerr. Once again, Nikki Tyree, Executive Director for the League of Women Voters. We've all heard today the best way to ensure democracy is to make sure that the voters stay in the process and are not cut out. Currently, we have a system where when a chair is resigned, the Central Committee will appoint somebody to fill that chair. However, as we know from self-reporting by voters, they are often not voting all the way down the ballot to the Central Committee. In fact, we would wager a guess that most voters couldn't actually name 2 people who serve on their county Central Committee. And as such, they are giving over a lot of power to the Central Committee to make those appointments. This has led to roughly 33% of the General Assembly being initially appointed instead of going in front of the voters, with Montgomery County actually holding about 41% of initially appointed. More distressing than that, over the last 2 years, we have seen full districts getting initially appointed as opposed to being elected by the voters. What we have found is that quite frankly, voters become apathetic. They don't know who actually serves them. They have no clue how the process works, and then they are just as confused by the names that come up on the ballot. So what we are asking is to pass Delegate Foley's bill, which would, in some respects, put that power back to the voters and allow them to once again get re-involved in the democratic process. After all, voting is the point of democracy. So we urge a favorable report. Thank you.
Thank you, sir.
You're welcome. Now are there any questions for the panel? Okay, seeing none, let's bring up the virtual witnesses. And let me say that Christopher Cano, we were having technical difficulties. We're unable to hear his testimony. But committee, he did submit written testimony. I urge all of you to take a look at what Mr. Cano submitted. So we have Edward Fishman and Jason Siegel.
Right. Can't seem to start my video. I hope you can at least hear me.
Yes, we can hear you.
Okay, great. Okay, sorry. Good afternoon to the chair and committee members. I'm Edward Fishman, Montgomery County. Like Ms. Smith, I serve on our County Democratic Central Committee. To answer Delegate Fair, 5 of the 7 vacancies we have filled this term would have been impacted if this legislation was already in place. I have a few concerns with the process, the biggest being anointing unelected appointees as incumbents who are then very likely to be strongly positioned on a slate with other incumbents seeking re-election. There is no perfect electoral or governing system, but outside of Central Committee members, it is hard to find anyone who likes this aspect of the current system. I regularly hear from voters who object to our choosing a district's elected representatives. I also hear from residents with more prosaic criticisms about the people we have nominated to send to Annapolis. Either way, their frustration is more acute because appointees usually end up serving multiple terms. I recently wrote in Maryland Matters in favor of a placeholders rule to disqualify appointees from running for the seat in the next election. Others argue for special elections whenever a vacancy occurs so the district voters would fill the vacancy. There's merit there, but HB 50 takes a more measured approach to address the democracy deficit and incumbency problem. Pairing with the presidential primary may actually be the best way to hold a special election, as it avoids any additional public cost and avoids having rushed, likely low turnout special elections. Because most vacancies occur in that first year, it really is a significant reform measure. Appointees seeking election will have to face district voters on their own at least one time in a competitive primary, but they will have plenty of time to raise money for a campaign before the fundraising pause. Passage of the bill will be applauded by almost all Marylanders and a strong answer to those who say legislators will always vote to benefit themselves. For her support, I thank Delegate Foley, who did benefit from the appointments process and also suffered through voting on vacancy appointments. I urge a favorable report on HB 50. Thank you very much.
Questions for Mr. Fishman? Seeing none, thank you, sir, for your testimony. We'll now move on to Jason Spiegel.
Thank you. I'm Jason Spiegel. I am also a member of the Montgomery County Democratic Central Committee representing District 17. Like my colleagues, I urge the committee to issue a favorable report on HB 50. Because only a fraction of a Central Committee's members live in any given district, appointments by the Central Committee give outsized influence to individuals who do not live in the district that has a vacancy. As a District 17 resident, I can only vote for candidates running in an election to represent District 17. However, as a Central Committee member, I voted to fill vacancies in other districts with which I am much less familiar. That is inconsistent with our democratic ideals. HB 50 would place the proposed constitutional amendment in the hands of the voters to decide how they want vacancies to be filled by election or Central Committee appointment. I want to thank Delegate Foley for her leadership on this issue and urge the committee to favorably report HB 50.
Thank you, Mr. Spiegel. I think we have one more person to testify in person, Mr. Weinberg. Sorry for the oversight. Push your microphone. Oh, there you go.
There we
Perfect.
go. Chair Wells, Vice Chair Kerr, distinguished members of this committee, thank you for the opportunity to testify again before you today. I'll be brief. I'm still David Weinberg. I'm still speaking for Protect Democracy United, and we encourage you to issue a favorable report on House Bill 50. This bill would incrementally but meaningfully strengthen Maryland's democracy. Because, after all, what is a democracy but a system of government in which the voters get to choose their leaders whenever possible? We've become accustomed to this practice of appointment, but that doesn't mean it's how we should always continue to operate here in the Free State in all cases, especially at a time when our nation's democracy is under significant pressure. We should aspire to set the best possible example for the rest of the country. This bill is also important for mitigating apathy towards civic participation, especially among our youth. If we want the next generation to agree that democracy is the right form of government, we should ensure that voters are the ones who get to choose their elected representatives when we can make it possible for them to do so. This bill strikes a reasonable compromise between lofty ideals and real-world practicalities, minimizing the burden on our hardworking election officials as well as on our taxpayers by only holding such special elections every 4 years on pre-existing election dates. Lastly, as Delegate Foley noted, if the General Assembly finally does send this referendum to voters this November, if it's approved then by the voters, Maryland can hold its first such special elections to fill legislative vacancies in 2028, but otherwise that won't be possible until 2032 at the earliest. For these reasons, we hope you will issue a favorable report on HB 50. Thank you for your consideration.
Thank you, Mr. Weinberg. And thank you for your patience as well.
Thank you for
All
your
right,
patience.
seeing
all
no
of you.
questions from the committee, that ends the bill hearing for HB 50. Thank you, everyone. All right, our last bill of the day, last but not least, Delegate Simmons, HB 101. Delegate Simmons, if you could have your panel join you, please, that'd be great.
Yes, thank you.
Okay.
Let me move down.
I think I have testifying, in addition to the bill sponsor, Davon Love, Joanne Antoine, Nikki Tyree, Andy Ellis, as favorable. Okay, great. With that, the floor is yours, Delegate.
All right, good afternoon, Madam Chair and Vice Chair and distinguished members of this committee. Delegate Simmons on House Bill 101 from Northern Anne Arundel County, District 12B. This is reference to public broadcast, debate for candidates, statewide office, required participation. So as you know, dealing with the public broadcast system over the years is about fair equity when it comes to candidates that are running for office that have qualified to participate in the voting election process, making sure that they have access to the public broadcasting system to make sure as a qualified candidate that they're able to have access to public broadcast television. We are working on that to make sure that we are fair and equitable here in the state of Maryland. When you look at civics in a manner in which it works and making sure we're getting the right information to all citizens, this becomes critical in everything that we're doing. So I have a distinguished panel here who are bringing expert witness testimony, and I would like to yield the floor for them at this time. Thank you, Madam Chair.
Thank you very much. Mr. Ellis, good to see you.
again.
Good to see you as well. Thank you all for the opportunity to testify before this committee. I'm really excited to have this committee exist. It's become my new favorite YouTube channel to watch during the day. And so I'm excited to, my name is Andy Ellis. I'm a Green Party candidate for governor this year. And I want to start with a quote from the Maryland Public Television editorial policies, which explains their unique role as a public broadcaster in hosting debates for high-profile races. On page 26, in a section that establishes rules for political debate, it says, MPT has a history of serving the people of Maryland by organizing and producing political debates in high-profile races. As the only television broadcaster with a truly statewide reach, MPT is uniquely positioned to perform this service, and it's part of MPT's commitment to help viewers make informed decisions as they participate in the political process. HB 101 proposes that the best interest of the people of Maryland is served by inviting all general election candidates for statewide office to any debate held by a taxpayer-funded public broadcaster. It's a very narrow bill that focuses on something that happens about 5 times every decade. In the status quo, MPT maintains sole authority to make those decisions. The current editorial policy all but guarantees that only candidates from the 2 major parties will be invited to the debate. I'm happy to go into detail about why I think that is the case if anyone has questions, but for now, I'll say that. A better standard, and what the bill proposes, is to use the ballot as the baseline. In 2022, there were 5 candidates for governor on the ballot. And I think the debate that occurred between Dan Cox and Wes Moore would have been more informative for the voters of Maryland if it had included the Libertarian, the Working Class Party, and the Green Party candidate. I urge a favorable report on HB 101 because I believe the voters are best able to make informed decisions and participate in the political process when they are aware of the views and ideas of all the candidates on their general election ballot.
Thank you, Mr. Ellis. Ms. Antoine?
Yes, Joanne, sorry, apologies. For the record again, Joanne Antoine with Common Cause Maryland, testifying in support of House Bill 101, which would ensure that voters have the opportunity to hear from all statewide candidates that will be on their ballot during a general election. Now, obviously, as a watchdog organization, we work closely with the press and consider them a partner in our work to create greater accountability here in the state. And that is because, press is a trusted media, they are trusted media outlets, that ensure that, Marylanders are aware of the decisions that are being made around them. And, while we want to maintain that independence, in this case, it should be, that these platforms also allow Marylanders the opportunity to hear from them all. Earlier today, we shared again and again how there's over, 1 million voters who are unaffiliated, and even those who are registered with a party, they don't necessarily identify, with that party, right? They are strategically registering in order to engage, in order to vote during the primary election. Those voters should hear from all of the candidates. Similar to our working coalition, right? We're bringing a lot of different ideas. We are challenging each other. I do believe that on a debate stage, right, having those from other parties allow for greater discussion, robust, to touch on issues that maybe, the majority parties right now are unwilling to explore, to address to the public. So, we view this as a good governance bill, right? We on our end, we take no position specifically, on how we hold these entities accountable, right? We do think that there should be some process for dealing with the violations. But again, this is where we're deferring, to the leaders that are sponsoring the bill and obviously the committee on how to navigate that, right? So again, these are reasonable standards that I believe works on that builds on the work of trusted, accessible sources that play a role in our public education. Giving candidates a platform helps to meet that goal. We'd urge a favorable report. Thank you.
Thank you. Ms. Tyree?
Thank you, Chair Wells, for the last time today, I promise. Nikki Tyree, Executive Director for the League of Women Voters of Maryland. We are in support of HB 101, which would mandate that all candidates be allowed to be included on the candidate forum stage. As you know, the League of Women Voters is famous for its candidate forums. Some of you might have participated in them at our local level in the past. And we make it a point to be as inclusive as possible with our candidate forums. But oftentimes, we do try to partner with press, media, state-funded media included, in order to put on those candidate forums to broadcast that out. Not saying that we've had controversy or conflict about who we include on the stage, but we believe that it shouldn't be a matter of choice to include everybody, but it should be a matter of practice. And HB 101 gets us a little bit closer to having that be a practice. The passage of this bill would ensure that public entities have to have inclusive stages. In order to have a robust democracy, it is imperative that voters hear from everybody on their ballot. We would like to avoid voters getting to the polling place and they see someone running for the first time. Nobody should be surprised by a name that they see on the ballot. On a personal note, for myself, I actually voted outside of the party that I typically vote for because I was able to go to a League of Women Voters candidate forum and witness all parties being represented on that stage. So we are just asking the committee to please codify this so that we can make this a more normal practice. And with that, we urge a favorable report. Thank you.
Thank you. Mr. Love.
Okay.
All right, good afternoon. The Democratic and Republican parties are multi-billion-dollar corporations that are extensions of this white supremacist settler colonial social order that have effectively marginalized perspectives from the political mainstream that speak unapologetically to those of us that want collective freedom and liberation for the masses of Black people and other oppressed people in this society. While there are many who may find this perspective offensive to their view and understanding of the world, this perspective deserves a place for credible political contestation. Black people are largely a captured electorate of the Democratic Party. Given the more explicit white nationalist commitments of the Republican Party, we are often having to negotiate with the kind of white-dominated corporate Democratic Party establishment that often prefers to pander to our community to the extent that it does deliver. It is often by the force of grassroots political pressure to the extent that they do deliver. For those of us that don't have millions of dollars, like the two major parties have, our leverage is our political participation. I was elected in 2022 to the Democratic Party State Central Committee in my home district in the 41st Legislative District. There's a cold war within the Democratic Party that is a hot war nationally between the centrist and progressive wings of the Democratic Party. Those within the 41st District that I would describe as representing the more moderate wing of the Democratic Party worked to push me off the State Central Committee. They used attendance from early 2023, didn't get an expulsion letter until late 2024. And in the conversation, in the hearing about my expulsion, what came up were my political views that I expressed publicly about the need for credible threats to the Democratic Party politically to their left. This was, and it was such something that was an exception in terms of how they proceeded that the parliamentarian actually said that needed to be struck in from the record in terms of the conversation about my particular case. But the conversation had already been said in the context of the discussion. This bill doesn't solve that problem. What the bill does do is provide an opportunity for those who carry perspectives like mine and many folks who aren't represented in the political mainstream to have an opportunity for their perspectives to be engaged in ways that the two-party system often marginalized. Thank you.
Okay. Delegate Stewart has a question.
Thank you, Madam Chair. Thank you all for coming. Delegate Simmons, thank you for the bill. Mr. Love, I'm very sorry to hear that happen to you, and I really appreciate your perspective. Mr. Ellis, you know that I've been a fan of yours for a long time. I personally, as a voter, would love to see you on the debate stage in November and any other time you want to run. But I have one concern about the bill. I think it's a good idea. I would vote for it. My problem is I just read, I'm a lawyer, I'm not a very good lawyer, but I just read the FCC versus League of Women Voters case, which seems directly on point, which basically says that the government cannot condition funds to a public broadcaster and ask them to, asking them to surrender essentially editorial discretion, even if they can decline the funds. So this happened in like the 80s. Basically, Congress passed this law that says that if a broadcaster takes public funds, they can't have any editorializing. And the Supreme Court struck that down in a 1984 opinion and said, actually, no. Even if they had the opportunity to decline the funds, that's coercive government behavior under the First Amendment. And I think that's very clearly directly applicable to what you guys are trying to do here. Otherwise would be an awesome idea. My question is, how do we get around the pesky Constitution?
Yeah. So I'm not a lawyer either. I'll say that at the beginning. But I think that there's recent FCC decisions that actually would probably challenge that to some degree. And I think it is worth looking at the decisions that have come out of the FCC recently about these access questions. I think the question from the 1980s, as you're citing it, needs to be revisited in light of recent FCC, rulings on this. Those are not those are administrative rulings. Those are not at the level of the Supreme Court at this point. But I think there's an opportunity to revisit that, and I think the FCC is opening the opportunity to revisit some of those questions. Again, I don't want to get into a legal conversation between two non-lawyers, and I think there can be good follow-up to that question, but I think that the conditions have begun to change a little bit over time, and I think it's worth this committee exploring that, because I think there are other states that are looking to Maryland right now to understand if we can figure out a way to do this thing that you agree with, I agree with, and many people up here agree with.
And if it helps too, I can look into greater detail, but I know New York City, for example, and this is specific to public financing, but again, these are platforms that are similar to Maryland Public TV, and then we have candidates now that are receiving tax dollars, right? They are required to have certified candidates that have qualified for those matching funds and so forth, that they're required to participate in the debate. So I can look for more detail, and we have access to FCC, so we can also work with Andy to see if an expert can also talk to you all. But in New York City, they do allow. Yeah, they do require that those that are receiving public dollars, both the candidate and the entity hosting the forum, that they are required to have them all at the forum.
Mm-hmm. Okay. Yeah, and I've read some of these FCC cases that Mr. Ellis mentioned, Russ versus Sullivan. And by the way, I am an attorney. I just meant that I'm a bad attorney. No offense taken. No, I'm just not a constitutional attorney and not a particularly good attorney generally. But I did read the case. I've read some of these FCC things. I think it's pretty obvious that we can't do this. I think it's kind of annoying that we can't, because I think this is a good idea. But let me just pose one devil's advocate argument to you guys, which is that maybe the Constitution is good, assuming I'm right, that it bars this bill, right? And let's say the Constitution is good. And let's say it's good because it provides some kind of limiting principle to prevent future legislatures from mucking around here in a way that's a little bit grosser. So, for example, do you guys think it would be constitutional or unconstitutional if we amended the bill to say that, for example, Delegate Barry Siliberti, who stepped out, was the moderator of every single panel going forward?
No.
Do you think that would be constitutional or no?
I think that would be a problem. I think there is a question that is unique about who is invited to participate that is dictated by the ballot access laws that this committee sets, that is worth isolating.
So you think the moderator thing would be unconstitutional, but this would be constitutional?
I don't know the constitutional question, and I'm not going to weigh in on that. One other thing, if you decide that this is a bad bill, because
no, I don't think it is.
If you decide that you think there's a constitutional problem to this, I think there are other ways to get at this that could happen in other legislative sessions. For example, in New York and New Jersey, the state has power over determining who is on the debate stage, and then they invite the sponsors to come cover the debate. So I think I do not think that the constitutional problem stops this committee from going forward with this bill. I'm not a lawyer. The lawyers may decide that we're wrong on that. If that is the case, and you think this is a good bill, I think there's an opportunity to reapproach this question via a different means that looks to some of our electoral peers in places like New Jersey and New York in order to figure out a system that actually works for Marylanders and for what you, me, and other folks want.
That's totally fair, and there may be some other ways. And I would just say, and sorry, I'll let you go too, Mr. Love. I would just say, if the sponsor, if you wouldn't mind, maybe getting an AG opinion letter or something like for us, I think that would be really helpful. I appreciate it, but yeah, sorry, Mr.
And I just wanted to just to impress upon the committee, the example that you give, I think, is different in the sense that the being on the ballot is an objective metric in terms of determining. It is much less subjective than the example that you gave. So I imagine, again, not being an attorney, I imagine that given the case law, that impacts the nature of how a lawyer may determine the constitutionality of this.
You would think, and Barry would make a great moderator, to be clear. I mean, he's not here right now, but I promise you he'd make a good one. No, and we can get, I don't want to get into it. It's just about editorial discretion. My concern is that whether it's restricting a moderator to a certain individual, whether it's us saying that the Republican Party can't participate in debates, or whether it's us telling the public broadcasters who is in and who is out. I worry, based on the Supreme Court precedent, that all of that is impinging on their editorial discretion in a way that flouts the Constitution. We'll get to the bottom of the AG letter, and maybe if I'm right about this, and maybe I'm not, but if I am, then I think Mr. Ellis makes a really cogent point that maybe we can look at some other alternatives to make sure that all voices can still be expressed. Yeah, thanks.
All right, thank you very much. Very valid questions that there's a lot to discuss there that will be robust for a subcommittee. Well, the next question we have is Delegate Fisher.
Thank you, Madam Chairwoman. This is for Mr. Ellis. I read the bill and I know what it does. It seems pretty straightforward. What if instead of relying on the public broadcasters or broadcasting in general, why not just reach out to the individual candidates who are filed and see if they'll debate you? Because with YouTube, TV and YouTube itself, and all the different social media platforms, it seems like I'm not saying, I know that you want this bill, but I'm just saying it as a stopgap in the meantime. Because my gut is that there are Republican candidates who have filed who would be happy to debate you, in a friendly way.
Sure, and I would welcome any of those debates anytime. Mr. Sobretti can moderate them. Delegate Sobretti, sorry, can moderate them. But that is not the question.
Maybe not the best idea.
Hey, whatever. I'll take whatever. But that's not the point here. The point here is that public television has a unique role in serving the public interest and engaging in public information according to their own standards about how to make sure that voters are the most informed. I think that no matter what the answer to the constitutional question is, I don't think that anybody can look at the way that Maryland Public Television is currently structuring these debates and say that they live up to their own mission, which is to inform voters.
Notwithstanding all the other issues that my good friend here mentioned, I think it's admirable that you're willing to debate anyone.
Yeah, sure.
Because it is a problem. I think that that's wrong. I think debates should include everyone that's filed.
Right.
Thank you.
Thank you.
All right. And now to my constitutional expert on election law, Delegate Fair.
Moderator Celebrity's not here. That's your constitutional expert here. Thank you so much for the opportunity, and I appreciate my colleagues bringing up the issues that they've brought up or questions that they've brought up. I have some technical questions that I just kind of want to get into. One of the major concerns that was outlined in some of the testimony on this bill was concerns around the definition of public broadcaster. They saw, as most of you have commented so far up there, you've mentioned Maryland Public Television repeatedly. However, that's not what the bill technically says. The bill says that public broadcasters are any institution that takes state dollars, which can include private entities and not-for-profit and nonprofit and for-profit, governmental agencies as well. And so is it the intention to just be to apply to Maryland Public Television, or did you want this to apply to affiliates, CBS, Fox, NBC, et cetera, as well, if they host one of these debates?
I would just say that, we're open. I think we would like, for this to apply to any of the major entities that are going to sponsor statewide general election debates. And I think the definition of public broadcaster was just a way to try to, because we don't want to necessarily single out Maryland Public Television. But certainly, to the extent that we can make progress on ensuring that happens is what we're looking to do.
Okay.
And I would say, I would love it if all of the networks opened up to debate for all the candidates. But I think the intention when I have thought about this is Maryland Public Television and any public broadcaster. And if there's a clarification that needs to be made, as Davon said, I'm open to that. I think the focus is on the unique role that Maryland Public Television has to serve the public interest and inform the voters that is different from any other broadcaster in the state of Maryland. And I think, for me at least, the focus is on having public television be in the public interest.
And I struggled with whether or not I could, because we defined the term in the first section of the bill about the general election. And so were we intending for this bill to only apply to general elections or general and primary elections? And if so, why only general elections?
I think it's largely up to the parties in some ways in the League of Women Voters to facilitate debates for the primary elections for the parties that get to have those. I think Maryland Public Television, I don't know that they have a habit of covering primary debates. As a person that doesn't get to vote in those elections, I typically probably don't watch those if they do cover them. But I think the general election is unique and Maryland Public Television's role is unique. And so for me, at least, the intention is to focus on the general election ballot so that voters are able to have the information that they need about the candidates that they will see on their ballot.
Okay. Thank you so much, Mr. Ellis. I appreciate the time. Appreciate you, Madam Chair.
Thank you to the committee for those great questions. All right, with that, thank you to the sponsor panel. Thank you to all of you that are among my frequent flyers, I think, in this committee. So I look forward to seeing you again. We will move on to our next panel we have Mr. Bradshaw. And I think you're the last person today, Mr. Bradshaw. If you are anyone, for favorable, excuse me. Thank you. Thank you, yeah. He's the last favorable witness on this bill, to clarify.
Lee Bradshaw, Maryland Forward Party. It's the last time you're going to see me today. It's been a pleasure and it's been a privilege. So a lot of good arguments in the last panel. A lot of good issues raised that have to be straightened out. But what for us, the key phrase here is all candidates certified to the ballot for statewide office. And we believe that if there's going to be a debate, then all those people, since they're willing to raise the money, do the work, and then serve in public office, need to be allowed to be in the debate. So we support a favorable position, and we hope you pass it. Thank you.
Thank you. Okay. Seeing no questions, Mr. Bradshaw, thank you for being with us today. Delegate Simmons, thank you. We're going to move on to the unfavorables. We have one person virtual, Mr. Pearson Cost, and I believe we have one person in-person unfavorable, Ms. Rebecca Snyder. Hi.
Thank you all for hanging in there. This has been a day, my goodness, so I'm sorry to be one of your last speakers. For the record, my name's Rebecca Snyder. I'm the Executive Director of the Maryland-Delaware DC Press Association, and we oppose this bill. And I do believe that everyone needs their day in the sun and voters need to be more educated, but it shouldn't come at the detriment of editorial control by your public broadcasters. You've just seen the federal government defund public broadcasting. What this bill does is put the government and the state in the situation of saying, this is how you need to conduct your operations. That is unconstitutional. I don't think Maryland should be pussyfooting around saying, oh, this might work or this might not work, when no one has even gone to MPT to say, let's talk about your editorial policies, which are very clearly stated to say that you need 10% of a poll to be invited to the general election debate. That's not my deal. I don't make any decisions around our members and how they conduct their operations, but certainly partners like the League, partners that MPT teams with, could talk to them about that. I don't think you need legislation. I don't think you need unconstitutional legislation about this. I also feel like the definition of what a public broadcaster is so broad that you are going to catch every broadcaster out there, because it says if you accept any money from the state. So that's if the state's running an ad for Maryland Lottery, if that's, it's anything. And I don't think that this is the start of something really bad for ostensibly good reasons. Yes, we want to educate the public, but we don't want to say, I'm sure Delegate Siliberti would be a terrific moderator, and this will be a lesson for him never to leave the room. But where does this end? I mean, and on these philosophical issues, like, you just don't know what the next thing will be. And I think we really need to guard against that. So I'm sure the broadcasters will talk about all the FCC and the technical stuff. That's not really my expertise. But I just know that this is an overbroad bill that we should try different ways to get more voices into the process before you legislate. And we do urge an unfavorable report. Thank you.
Thank you, Ms. Snyder. We will move to our virtual, Mr. Pearson Cost.
Hello again.
You've changed locations, Mr. Cost.
I'm sorry about that. There was a technology issue.
All good.
Thank you for having me in my new location.
I know you from the previous one, so I know that I'm looking at you despite how far you are from the camera. But no, in all honesty, though, 2 minutes. Thank you for sticking with us.
Thank you. Hello again. My name again is Pearson Cost. And as I mentioned earlier, I serve as counsel to the Maryland, DC, Delaware Broadcasters Association. The association, on behalf of its approximately 20 television station and 110 radio station members, strongly opposes House Bill 101. In what's a challenging time for journalists of all stripes, the association's members work daily to seek the truth and report it, and to promote open democratic discourse. Those efforts, however, are hampered when the government injects itself into how journalists cover the issues. And journalists cannot function when in fear of retaliation, economic or otherwise, for their editorial choices. In addition to the First Amendment concerns that have already been discussed and we certainly agree with, the association does not believe that it is appropriate for the government to dictate editorial decision-making, particularly where First Amendment protections are at their zenith, the political speech bearing on free and fair elections. House Bill 101 would unfortunately do just that. But worse, the legislation goes one problematic step further in proposing that the state can economically punish a broadcaster if they do not engage in the type of speech mandated by the state. Additionally, it's worth noting that an extensive, complex federal statutory and regulatory framework already governs radio and television broadcasters. Members of the public may address concerns directly with the FCC if they believe a television or radio station is not serving the public interests, which they are already charged with doing. MDCD urges an unfavorable report of House Bill 101. Thank you.
Thank you, Mr. Cost. Okay, I do not see any questions from the committee, so I want to thank you all for your testimony. That concludes our bill hearing on HB 101. It also concludes our bill hearings for today. I just want to thank the public for your participation in the process, but also everyone, just being professional, and I appreciate the decorum. So with that, this adjourns the hearing for GLE. Yeah, that first one I had to I was like, sit down, people.